May I have my lordship's kind leave to once again I trouble your lordship. If your lordship recollects, on Thursday, 8th of August, I mentioned a matter. My lord, today is appearing as 34, and my lord directed the matter to come immediately after the parted matters. I've stated all that, my lord. I'll be there. Yes, my lord. Yes. Contested applications are all there, my lord. Yes. Lordship.
My lord, on second appeal of 1971.
Is it 1971?
71.
Ready for hearing?
Yes, yes.
You are for the
Appellant.
appellant. Paper books are there.
Yes, yes. Everything ready was. Ready one.
My lord, I am mentioning item number 86 of the day's list, my lord. On 10th of August, Lordship has heard this matter and has directed, let the matter appear on 21st under the heading hearing at top. My lord, it has gone down to 86, my lord.
নিন এটা এটা কি করবেন দেখুন let the senior mention
On two constitution application.
in respect of
The both of one matter appellant was died and another
in respect of
appellant.
you mention
Your Lordship, the
come prepared to tomorrow.
contested application matter ready for hearing. My Lord, kindly take up this matter.
নিন।
Eject me.
But this bench won't be available for the coming 2 weeks. Let me be clear.
Where may I be permitted to
The
mention
circuit bench.
to civil revisional application mention with that with prior notice to the other side, my lord, for under heading inclusion under heading hearing, my lord.
Contested application.
Yes.
শুনুন যেগুলো নিয়ে নিন আর আরেকটা জিনিস হচ্ছে
Also.
নেক্সট ডাকুন লিস্ট ডাকুন
Item number 1,
Mr. Dotto has completed. You have to give the reply.
My lord.
খাতা করুন, খাতা করে লিখে রাখুন।
হুম।
ওই দিন সেকেন্ড অ্যাপিল যখন হবে না, পেপার বুক দেবেন।
Make please, your lordship. Initially, the suit was filed for declaration and injunction. Subsequently, it was amended in the year 2004 or 2005, and prayer was made for recovery of khas position.
Added.
My lordships, kindly come to part 2 of the paper book, my lord.
Yes, part 2.
My lord, the plaint, my lord. That the property described in the schedule below originally belonged to Phonibhushan Datta lordships. What? Page 4.
Page. Yes.
Ishtava Datta, Bhornath Datta, and Umanath Datta, sons of Pratap Chandra Datta. They were the owners of the suit property in equal share. CS record stands in the name of Ishtava Datta, Bhornath Datta, and Umanath Datta, and amongst the three brothers due to amicable arrangement and partition. Umanath Datta got the suit property exclusively. Bholanath Datta and Ishtava Datta got other properties in lieu of suit property. And heirs of Bholanath Datta and Ishtava Datta are implicated as pro-defendants in the suit. That Umanath Datta, being the exclusive owner of the suit property, raised paka structure over the suit land consisting of one room, having two veranda in the southern side and northern side. Pro-defendants, sons of Bholanath Datta and Phonibhushan Datta and Ishtava Datta have no right, title, and interest in respect of the suit property, and in order to avoid future complication, they are implicated as pro-defendants in this present suit. That Umanath Datta used to possess all the suit lands, including structure thereon, peacefully. After death of Umanath Datta, present plaintiffs as sons and daughters inherited the suit property, and they have been possessing the same. Shobharani Datta was the Bhagina of Uma Datta. Shobharani Datta was issueless, and after death of her husband, she took shelter at the house of Umanath Datta. She had no manner of title, pretense of title, and suit of possession in respect of the suit property, and she used to live at the house of Umanath Datta. But at the time of RS operation, in 13 column, name of Shobharani Datta had been recorded as the owner, and in 23rd column, name of Umanath Datta had been recorded as Anumati Dakhal.
1 minute. Earlier it has been mentioned as Shobharani Datta. Herein it is mentioned as Shubha Nandini Datta. What is the
Both are same.
same person?
Same.
1 minute.
Shubhanandini.
Yes.
Owner in 23rd column of Umanath Datta had been that, but at the RS operation in 13 column, name of Shobhanandini Datta had been recorded as the owner, and in 23rd column, names of Umanath Datta had been recorded as Anumati Dakhal under Shobharani Datta. This very recording is completely baseless and wrong. Even LR record is prepared wrongly in the name of Shobharani Datta. That Shobharani Datta has had no right, title, and interest in the suit property, and Shobharani Datta, having no right, title, and interest in respect of the suit property, had executed and registered a document in favor of the defendant number 1, Devnath De, sister, son of Shubhanandini Datta, along with other properties. But the defendant number 1 did not acquire any right, title, and interest in respect of the suit property. Now the defendant number 3, on the basis of the erroneous entry of RS record and LR record, and on the basis of so-called registered document, claims and possesses himself to be the owner of the suit property. And the defendant number 1 is attempting, let us kindly mark it, attempting to dispossess the plaintiffs from the suit property. So the plaintiffs, finding no other alternative, are filing the present suit against the defendant for declaration of title and permanent injunction, and title of the plaintiffs had been clouded due to erroneous entry both in RS and LR record of rights. Lordships kindly marked it. When it has been attempted, how it has been attempted, this has not been mentioned. Kindly take note of this, my lord. Attempting to dispossess the plaintiffs from the suit property. But when, how, nothing has been mentioned. So identity order of injunction and temporary injunction ought to be issued against the defendant number 1, restraining him from disturb the peaceful possession of the plaintiff in respect of the suit property. For the purpose of jurisdiction and for a dispute, suit is framed under 4B of Court Fees Act and etc. Cause of the action of the suit arose on and from 10th Asar 1400 when the defendant attempted to dispose the plaintiff from the suit property.
That date is mentioned. Now, suit for recovery.
Now it is suit for recovery of possession. Let's kindly note it.
Later on, recovery of possession has been added.
But nothing discloses.
But nothing disclosed when and how they have been dispossessed. He has been dispossessed.
It's very vital for recovery of possession for counting limited under 64.
Yes.
Now, suit of recovery of in case of suit of recovery possession, the date is very much required because the limitation period is to be considered as per section 63 and 64 of the Limitation Act from the date, yes, article 63 and 64 of the Limitation Act. Since when and how he has been dispossessed. And plaintiff completely silent about the date of his and manner of his disposition. How and in what manner?
My lord, have you look into my lord LCR, my lord, LCR to দেবেন একটু লোয়ার কোর্টে করতে
Yes, Mr.
LCR going on.
আপনাকে দিয়ে দিন ওই ট্রায়াল কোর্টের রেকর্ড টিএস থাকবে
Amended application is required to be seen. This part of the plaint.
This one is not the amendment one amended
Amended plaint. Yes, amended application is part of the plaint.
so, herein suit for declare
That is my lord.
this one is not the amended plaint. This one is the
No, this is the
first
plaint in the.
This is the amendment plain.
Here is
After amendment, the amendment plain will go.
In handwriting, you also will find.
one minute. Oh, acha, in handwriting, yes. For recovery of khas possession of the suit
And when
property and valid
সংশোধনী
notice
অংশ
certificate.
পৃথকভাবে রইল।
When is that?
That when sometimes the trial court passes orders,
No, 1 minute. Obviously, amended plaint has been filed.
not on a
And
sometimes,
this is that amendment plain.
sometimes court directed that amended application is part of the amended plaint. That I'm saying.
My learned friend cannot
Learned counsel,
inducted it.
learned counsel, it is hard to digest
No,
My lord.
your lordship is perfectly right, but your lordship will find that
because after the order 6 rule 17 is allowed,
there is
there
provision
obviously there will be a date fixed for filing the amended plan.
under order C rule 18. That is the provision, but sometimes the short amendment
Hmm.
that may be court recorded that I argued in
Mr.
another.
Mr. Datta, 1 minute. There is addition of recovery of possession. Is that a short amendment?
No. Sometimes in the trial court,
Yes, whatever may be, it is mentioned for recovery of khas possession.
that has been part of the thing.
So when it has been when they have been dispossessed and in which manner they have dispossessed, that has not been mentioned in elsewhere.
It has been mentioned, this is the 4th time.
And my lord, 63 and Article 63 and 64
Of the
of the
Limitation
Limitation Act
363.
applies. My lord, next page 7, my lord. That is written statement.
In
Page
Bengali,
7, my lord,
in Bengali,
in Bengali. My lord.
this is the additional written statement.
My lord, both are there. In the next page, it is there.
Next page, please.
On after 2 pages, it is there. Page 11, my lord. Page 11.
Yes.
My lord, বর্তমান আকারও আইনমত বাদীর আদৌ মেনটেনেবল নহে। ওয়েভার এস্টপেল অ্যান্ড অ্যাকুইশনস নীতি অনুযায়ী বাদীর বর্তমান মকদ্দমা অচল। স্পেসিফিক রিট অ্যাক্টের 34 ধারার বিধান মতে বাদীর বর্তমান মকদ্দমা বাড়িত। নালিশি দাগের স্থানাদি বা ডেসিমেল ইহাতে 1 নম্বর বিবাদীর পূর্বাধিকারী নন, উহার পূর্ব মালিক আর্জির কর্তৃত্ব মতো ফণীভূষণ দত্ত ওরফে ইষ্টপদ দত্ত, ভোলানাথ দত্ত, উমানাথ দত্ত, সর্বপিতা প্রতাপচন্দ্র দত্ত গত বাংলা 1338 সালে একখণ্ড দানপত্র দলিল মূলে উহা রেজিস্ট্রিকৃত নহে। নালিশি স্থান 1 নম্বর বিবাদীর পূর্বাধিকারী শ্রীমতী সুভাষিনী দাসীকে দান করিয়া দখল ভোগ ছাড়িয়া যান। মানে দখল ভোগ ছাড়িয়া যান এবং তথায় সুভাষিনী দাসী উক্ত দাতাগণের সহায়তায় একটি বসত বাটি নির্মাণ করিয়া স্বামী কন্যা সহ বসবাস করিতে থাকেন। সি ইজ পজিশিং। সুভাষিনী দাসী পরলোকগমন করিলে 2 কন্যা রাখিয়া যান।
So,
তন্মধ্যে
Lord Counsel, which one you are emphasizing? Only to possess?
Yes, my lord. Lordship is correct. Lordship is 100% correct.
Not absolute interest, but possession only. You are embarking on that point.
My lord. My lord. তোমার 1338 সালে একখণ্ড দানপত্র দলিল মূলে নালিশি স্থান 1 নম্বর বিবাদীর পূর্বাধিকারী শ্রীমতী সুভাষিনী দাসীকে দান করিয়া দখল ভোগ ছাড়িয়া দেন এবং তথায় সুভাষিনী দাসী উক্ত দাতাগণের সহায়তায় একটি বসত বাটি নির্মাণ করিয়া স্বামী কন্যা সহ বসবাস করিতে থাকেন। সুভাষিনী দাসী পরলোক গমন কালে 2 কন্যা রাখিয়া যান, তন্মধ্যে 1 কন্যা 1 নম্বর বিবাদীর মাতা। অপর কন্যা শোভারানী দত্ত রূপে শোভানন্দিনী দত্ত মাতার সহিত বসবাস করিতেন এবং তদ্বিধায় তাহার মৃত্যুর পরও নালিশি স্থানস্থিত উক্ত বাটিতে বসবাস করিতে থাকেন। উক্ত শোভারানী ওরফে শোভানন্দিনী নিঃসন্তান ছিলেন এবং মধ্য বয়সে বিধবা হন। তিনি উক্ত বাটিতে বসবাস করিতে থাকিয়া তাহার অংশাদি 1 নম্বর বিবাদীকে গত 21/3/93 তারিখে একখণ্ড রেজিস্ট্রিকৃত দানপত্র দলিল বুনিয়াদে হস্তান্তর করিয়া দিলে 1 নম্বর বিবাদী তাহাতে মালিক ও দখলিকার হন।
এই, এক নম্বর বিবাদী is the daughter of শুভারানী শুভনন্দিনী।
sister's son.
No,
Shubhanandini's sister's son. Those who are recited all together.
আচ্ছা, sister's son.
অপর কন্যা শোভারানী দত্ত ওরফে শোভারানী দত্ত মাতার সহিত বসবাস করিতেন এবং তদ্বিদায় তাহার মৃত্যুর পরও নালিশী স্থানস্থিত উক্ত বাটিতে বসবাস করিতে থাকেন। উক্ত শোভারানী ওরফে শোভানন্দিনী নিঃসন্তান ছিলেন এবং মধ্যবয়সে বিধবা হন। তিনি উক্ত বাড়িতে বসবাস করিতে থাকিয়া তাহার অংশাদি 1 নম্বর বিবাদীকে গত 21/3/93 ইংরেজি তারিখে একখণ্ড রেজিস্ট্রিকৃত দানপত্র দলিল বুনিয়াদে হস্তান্তর করিয়া দিলে 1 নম্বর বিবাদী তাহাতে মালিক ও দখলিদার হন।
Prior to this submission, learned counsel have stated that she is not claiming absolute right. She is claiming only possessory right. So, শোভারানী ওরফে শোভানন্দিনী had only possessory right. So, উক্ত শোভারানী ওরফে শোভানন্দিনী নিঃসন্তান ছিলেন এবং মধ্যবয়সে বিধবা হন। তিনি উক্ত বাটিতে বসবাস করিতে থাকিয়া তাহার অংশাদি 1 নম্বর বিবাদীকে গত 21/3/93 ইংরেজি তারিখে একখণ্ড রেজিস্ট্রিকৃত দানপত্র দলিল বুনিয়াদে হস্তান্তর করিয়া দিলে how can she give the gift? How can she gift this property?
But even then, if she is not entitled,
According to you, she had possessory right. Clear? How can she gift that property?
she has given the possessory right to him,
Acha.
and they are also, and she
According to you,
and
she had,
he is also on possession since his childhood.
she's, according to you, Shobharani Shobhanandini has given possessory right to the defendant number 1.
If it is considered that the gift deed is void, then
No, I'm not going into that point now. According to you, the Shobharani Shobhanandini will come step by step. Shobharani Shobhanandini had given possessory right to her sister's son.
exclusively, because he is also there. He is also in the property since his childhood.
Void this deed dated 21/3/93.
My lord. Previous to that, he was also on the residing on the said property with his mother and aunt. On the next line, Lordship's got it. Will got it.
Mm. Yes, let us now proceed.
Next page, my lord.
Hmm.
Next line, it will be proved. প্রকাশ করা যায় যে 1 নম্বর বিবাদী অল্প বয়সে মাতৃহারা হইলে পর তিনি মাসির নিকটই দাদু দিদিমার নালিশী স্থানস্থিত বসত বাড়িতেই বসবাস করিতে থাকেন।
মাসি না মামি?
It will be মাসি।
মাসি। Yes.
ইহার বিপরীতে আমি সমঅনুচ্ছেদে কথিত মতো ফণীভূষণ দত্ত, ইষ্টপ্রদ দত্ত, ভরনাথ দত্ত, মহানাথ দত্ত মহাশয়গণ নালিশী সম্পত্তির সমঅংশে মালিক ও দখলদার থাকিয়া নিজেদের মধ্যে আপোষ অ্যারেঞ্জমেন্ট বলে নালিশী স্থানাদি উমানাথ দত্ত একাই মালিক মাসিক রচনার কথা মিথ্যা। আর যে 2 নম্বর অনুচ্ছেদে বর্ণিত মতো উক্ত উমানাথ দত্ত মহাশয় নালিশী সম্পত্তির একে মালিক দখলিকার থাকিয়া পোক্তা ঘরবাড়ি নির্মাণ করার কথাও সম্পূর্ণ মিথ্যা। আর যে 3 নম্বর অনুচ্ছেদে বর্ণিত উমানাথ দত্ত মহাশয় শান্তির সহিত নালিশী সম্পত্তি ভোগিত করিয়া করিতে থাকিয়া পরলোকন করলে তাহার পুত্র কন্যাগণের নালিশী স্থানীয় ভোগিত করে করিতে থাকার কথা। শোভারানী দত্তের স্বামী পরলোক গমনের পর তাহার উমানাথ দত্তের আশ্রয়ে থাকার কথা। নালিশী সম্পত্তিযুক্ত ভরানী সত্ত্বের কোনরূপ সত্য দখল না থাকার কথা ইত্যাদি উক্তি মিথ্যা এবং মকদ্দমা জন্য কল্পিত কাহিনী মাত্র। ওই আর্জির উক্ত অনুচ্ছেদেই বর্ণিত মতো আরএস রেকর্ডের 13 কলমে শোভারানী দত্তের নামে থাকা সত্য হইলেও 23 কলমে উমানাথ দত্তের নাম অনুমতি দখলকারী হিসেবে লিপিবদ্ধ আকারে কথা বর্ণনাপত্রের পরবর্তী অংশে বর্ণিত মাত্র কারণে সঠিক নহে এবং এলআর রেকর্ডও ভ্রমাত্মকভাবে শোভারানী দত্তের নামে থাকার কথা মিথ্যা। নালিশি স্থানাস্থিত গৃহাদি এই বিবাদীর দখলে থাকার কথা এবং এই বিবাদী পূর্বাধিকারী সূত্রে নালিশি স্থানের পূর্বাসত্ত্বাধিকারীর নিকট হইতে বনপত্র দলিল মূলে প্রাপ্ত হইয়া গৃহাদি নির্মাণে দখল দিতে উদ্যোগী বহল থাকার কথা সম্পূর্ণ জ্ঞাত থাকিয়া বাদীগণ তঞ্চকি ও চাতুর্য মূলে ইহা চাপিয়া গিয়া নিজেদের দখল দাবি করিয়া বর্তমান মিথ্যা মকদ্দমা দায়ের করিয়াছেন। নালিশি স্থানের সিএস পর্চা যথাযথভাবে প্রচারিত আছে। আরএস পর্চার নকল এই বিবাদী সরকারি নিষেধের জন্য পাঠাইতেছেন না, কিন্তু বাদীর কথা মতো নালিশি স্থানের আরএস রেকর্ডের 13 কলমে শোভারানী ও শোভানন্দিনীর নাম থাকিলেও তা যথার্থ সঠিক, কিন্তু 23 কলমে অপর কারো নাম অনুমতি দখলকারী হিসেবে উত্তরে থাকলে তাহা মিথ্যা এবং কোনো ষড়যন্ত্র মূলে প্রসূত। নালিশি দাগের মালিকগণ অর্থাৎ ভোলানাথ দত্ত দিন তাহাদের ভগিনী সুভাষিনীকে দানপত্র দলিল করিয়া দিয়া দখল ভোগ করিয়া দিয়া গৃহ নির্মাণে সাহায্য করিলেও সুভাষিনীর মৃত্যুর পর তাহার কন্যা জামাতা উক্ত স্থানস্থিত গৃহাদিতে বসবাস করিতে থাকিলে সম্ভবত লোভে পড়িয়া উক্ত নালিশি দাগের আরএস রেকর্ডের এন্ট্রি কাটাবার জন্য এস্টেট অ্যাকুইজিশন অ্যাক্টের 1953 এর 44 ধারা অনুসারে এবং আপত্তি দরখাস্ত দায়ের করেন। An objection case has been filed as per Estate Acquisition Act 44B. উক্ত আপত্তি কেসে আপত্তি নম্বর এত মতো নথিবদ্ধ তাহা বিচার হয়, কিন্তু অর্থাৎ ফাইনাল অর্ডারটি কি হয়েছে তাহা এই 1 নম্বর যদি অবগত না হয় এবং পূর্ণতম কাগজপত্রের মধ্যে কেবল একটি পাঠালেও অপর কোনো কাগজপত্রটি পাঠাইতেছেন না। সেটেলমেন্ট অফিসে এই বিবাদী উহার মেদমরা করিতেছেন। অতঃপর ভূমি সংস্কার আইন মতো চলতি সেটেলমেন্ট আরএস রেকর্ডের ভিত্তিতে এবং সরেজমিনে পরিদর্শনে পরিলিখিত হইয়া উহা অর্থাৎ নালিশি স্থান ও গৃহাদির হাল সেটেলমেন্ট পর্চা যথাবিহিতভাবে এবং সম্পূর্ণ সঠিকভাবে শোভারানী দত্তের নামে প্রচারিত হয় এবং শোভারানী দত্তের নিকট মা ও পিতার ওয়ারিশ সূত্রে উভয় দফায় প্রাপ্ত হইয়া এবং মাসির সঞ্চিত পূর্ব হইতে বাসাবাস করার সুবাদে স্ত্রী পুত্র সন্তানগুলি লইয়া সকলকে বহিষ্কারে রাখিয়া পূর্বাধিকারী ক্রমে গত বাংলা 1338 সালের 22 ফাল্গুন হইতে নিজ অধিকার মূলে শান্তির সহিত নিরবিচ্ছিন্নভাবে অন্য সকলের জ্ঞাতসারে পূর্ব মালিক সহ সকলকে বহিষ্কারে রাখিয়া সরকারি নথিপত্র যথাবিহিত উন্মেষ সহ অদ্যাবধি দখল করিতেছেন।
So now you are stating
পজিশন
adverse position.
এবং তৎকালীন পূর্বোক্ত
Adverse position.
হ্যাঁ ইট হ্যাজ বিন রিটেন এবং তৎকালীন পূর্বোক্ত দান ছাড়াও অ্যাডভার্স পজিশন মূলে পূর্বাধিকারী কমে 1 নম্বর বিবাদীর একটা অভিমান সম্পূর্ণ অপ্রতিরোধ্য সত্য নালিশি স্থানে জন্মিয়াছে এবং ইহার বিপরীতে আমার 4 নম্বর অনুচ্ছেদের কথা মতো নালিশি সম্পত্তিতে শোভারানী দত্তের সত্য দখল মালিকানা না থাকার কথা সম্পূর্ণ মিথ্যা, উদ্দেশ্য প্রণোদিত, চাতুর্যপূর্ণ উক্তি। উক্ত অনুচ্ছেদে শোভারানী দত্তের নিঃসত্ত্বীয় আর্জি থাকা সত্ত্বেও 1 নম্বর বিবাদী বরাবর লক্ষ্মী সম্পত্তি সহ অন্যান্য সম্পত্তি দলিলমূলে হস্তান্তর করিয়া বা 1 নম্বর বিবাদী নালিশি সম্পত্তিতে কোনরূপ সত্য দখল মালিকানা অর্জন না করার কথা আরএস ও এলআর রেকর্ডের ভ্রমাত্মক বর্ণনার সুযোগে বাদীগণকে নালিশি সম্পত্তিতে উচ্ছেদ করিবার চেষ্টা করার কথা ইত্যাদি 4 নম্বর অনুচ্ছেদের এককালীন মিথ্যা ও দলীয়বন্দীমূলক এবং তঞ্চকিপূর্ণ মাননীয় আদালতের উপর ফ্রড প্র্যাকটিস করিবার জন্য প্রভূত উক্তিপত্র। They have not come in clean hands, it has been stated. এই বিবাদী পূর্বাধিক্রমে নালিশি দানের জন্য প্রদেয় খাজনা প্রথমত তৎকালীন জমিদারগণকে ও পরবর্তীকালে সরকার বাহাদুরকে আদায় দিয়েছেন এবং দিতেছেন। দ্যাট ওয়াজ রিটেন আমাই দিয়েছেন, ইট ইজ আদায় দিয়েছেন ও দিতেছেন এবং উক্ত স্থানাস্থিত গৃহাদির জন্য পঞ্চায়েতকে প্রদেয় ট্যাক্স আদায় দিয়ে আসিতেছেন। নালিশি স্থানে সুভাষিনী দত্তের আমলের মাটির গৃহাদি তাদের কন্যা শোভানন্দিনী ওরফে শোভারানী দত্ত রাখিয়া 1 কামরা 2 পক্ষে 2টি বারান্দা সহ পাকা পায়খানা বাথরুম নির্মাণ করিয়া যথাবিহিতভাবে সীমানা প্রাচীর সহ দখল ভোগ করিতে থাকেন এবং পূর্ব ঘটনা অনুযায়ী 1 নম্বর বিবাদী দখল ভোগ বসবাস করিতেছেন। বাদীগণের আর্জির 6 নম্বর অনুচ্ছেদের কথা মতো উল্লিখিত তারিখে বা সময়ে নালিশের কোনো কারণ উত্থিত হয় নাই। This was written statement, additional written statement, page 11.
Yes.
বর্তমান আকার ও আইনত মতে বাদীর বর্তমান মকদ্দমা অচল বাদী রাজ্যের কথিত মতো নালিশি সম্পত্তি হইতে খাস দখল পাইবার জন্য যে প্রার্থনা করিয়াছেন তাহা মঞ্জুরযোগ্য নহে এবং খাস দখল পাইবার নিমিত্ত নালিশি সম্পত্তির যে মূল্য ধার্য করিয়াছেন তাহা সম্পূর্ণ মিথ্যা এবং কল্পনাপ্রসূত। নালিশি সম্পত্তিতে এই বিবাদীর পোক্ত পাকা গৃহ ও তৎস বারান্দা পায়খানা মিলিয়া সমগ্র স্থানাদির সীমানা প্রাচীর দ্বারা ঘিরা লইয়া বসবাস করিয়া আসিতেছেন। উক্ত পাকা গৃহাদির মূল্য এবং তৎস নালিশ মূল্য লক্ষাধিক টাকা হইবে। টাকার উপর কোর্ট ফিস আদায় না দিয়া কোর্ট ফিস আদায় দিয়েছেন, সে কারণে উপযুক্ত মূল্য না করে এবং সঠিক মূল্যের উপর কোর্ট ফিস আদায় না দেওয়ার বর্তমানে মকদ্দমা অচল হইতেছে। নালিশি স্থানাদি ও তহসিল গৃহাদির মূল্য লক্ষ টাকার ঊর্ধ্বে হয় মাননীয় আদালতের আর্থিক অধিক্ষেত্রের বহির্ভূত হইতেছে। বাদী নালিশ সম্পত্তি বিষয়ে নিঃসত্ত্বীয় ব্যক্তি হইতেছেন। বাদী নালিশি সম্পত্তি বিষয়ে সম্পূর্ণ নিঃসত্ত্বীয় ব্যক্তি হইতেছেন। বাদীর বর্তমান মকদ্দমা মাই খরচা ডিসমিসযোগ্য হইতেছে। So the plain has been filed in two parts. Firstly, my lord, declaration of title, and secondly, my lord, by amending recovery of khas possession. Our case is recovery of khas possession. So our case is, my lord, as per give deed, alternatively recovery of alternatively khas possession. That is
Lord
adverse
Counsel-
possession.
Lord Counsel, you decide. There are three options. First one is absolute interest through the deed of gift, dated 21/3/93. Second is possessory right. And the
No,
third
that is first deed.
you have claimed three
But first,
rights.
my lord,
First is absolute right through deed of gift dated 21/3/93. Second is you have stated possessory right, and thirdly adverse possession. So which out of the three, which boat do you want to sell? In which boat you want to sell?
my lord, we have the right to take inconsistent view, being a defendant. My lord, we have the documents to show that we are in possession. We have the documents to show that it has been given gift to my aunt, though it is unregistered.
As recovery of possession has later been added, so it is obviously you are in possession. They are not in possession. That is clear.
But lordships kindly see, they have said we have dispossessed. When they have dispossessed, and in which manner they have dispossessed.
Much.
That has not been mentioned in anywhere. এটা দেখো, হ্যাঁ। In a suit for recovery of khas possession, one of the essential conditions is entitlement. Manner of entitlement specifies on the date and mode of disposition, and conversely, what is the nature of possession claimed by the defendant and how it is illegal. Admittedly, in the case on hand, these pleadings are completely absent. A few bits and pieces of evidence without pleading cannot be appreciated.
So you are stating that the plaintiff or plaintiffs, whatever may be, they could not produce, they were unable to prove their right over the suit property.
Their position over the suit property. Their position over the property. They are required by their filed into.
It is obviously they have lost possession. That's why they have claimed for recovery of possession. Now the court is seeking as regards to that your stance is now the plaintiffs or plaintiff has not been able to, or have plaintiffs have not been able to prove their case.
Yes.
Position in the suit property, recovery of position does not arise at all. Position in the suit property, recovery of position does not.
Huh.
Even if you
চিন্তা দেখো, এভিডেন্স দেখো, এভিডেন্স কোথাও বলেনি যে when they have lost their worship.
Kindly see the chief also. In the chief also, they have not disclosed that when they have dispossessed.
Which one? Which
Page
portion?
12.
Yes. Only one on behalf of the plaintiff, only one person witnessed.
Yes. PW1
PW1.
and DW2 DW,
On behalf of the defendants, 2 persons deposed.
my lord. P12, page 12.
Page 12.
আমি তৃপ্তি দত্ত, স্বামী অশোক দত্ত, she has given deposition on behalf of her husband অশোক দত্ত, who is the plaintiff hearing. 1 নম্বর বাদী আমার স্বামী এবং 2 নম্বর বাদী আমার ননদ হইতেছেন এবং আমি উভয়ের পক্ষে জবানবন্দি দিতেছি, ইহা আমার জ্ঞান মতো সত্য। নালিশ সম্পত্তির সমঅংশে মূল মালিক ও দখলিকার ছিলেন ফণীভূষণ দত্ত ওরফে ইষ্টপদ দত্ত, উমানাথ দত্ত, ভোলানাথ দত্ত এবং তাদের সাথে সিএস আমলের রেকর্ড চূড়ান্ত রূপে প্রচারিত আছে এবং তাহারা সহোদর ভ্রাতা ছিলেন। তারা নিজ নিজ সুবিধা মতো ঘরোয়া আপোষ বন্টন করিয়া লয়েন। তাদের সম্পত্তি এবং নালিশ সম্পত্তি উমানাথ দত্ত উক্ত ঘরোয়া বিভাগ বন্টন মূলে 16 আনা অংশের মালিক ও দখলিকার হয়েন এবং অপর 2 ভ্রাতা অন্য সম্পত্তির নির্দিষ্ট পণে প্রাপ্ত হয়েন, ইহা আমার জ্ঞান মতে সত্য। উমানাথ দত্ত নালিশ সম্পত্তি ভোগ দখল করিতে থাকিয়া পরলোক গমন করিলে বাদীগণ তার পুত্রকন্যা হিসেবে নালিশ সম্পত্তির 16 আনা অংশের মালিক ও দখলিকার হয়েন, ইহা আমার জ্ঞান মতে সত্য। শোভারানী দত্ত উমানাথ দত্ত এবং ভগ্নী ছিলেন, বোনের কন্যা ছিলেন এবং তিনি নিঃসন্তান ছিলেন এবং তাহার স্বামীর মৃত্যুর পর উমানাথ দত্ত এর বাড়িতে আশ্রয় নেন, ইহা আমার জ্ঞান মতে সত্য। নালিশি সম্পত্তিতে উক্ত শোভারানী দত্ত এবং কোনো রাইট টাইটেল ইন্টারেস্ট নাই বা ছিল না, কিন্তু ভুলক্রমে আরএস রেকর্ডের আমলে 13 কলমে মালিক হিসেবে লিপিবদ্ধ হয় এবং 23 কলমে উমানাথ দত্তের নাম অনুমতিদাতা হিসেবে উল্লেখ আছে, যাহা সম্পূর্ণ ভ্রমাত্মক হইতেছে, ইহা আমার জ্ঞান মতো সত্য। শোভারানী দত্তের কোনো রাইট টাইটেল ইন্টারেস্ট না থাকা সত্ত্বেও নালিশি সম্পত্তি সম্বন্ধে 1 নম্বর বিবাদী বরাবর একখানি রেজিস্ট্রিকৃত দলিল সম্পাদন করিয়া দিয়েছেন এবং উক্ত ভ্রমাত্মক আরএস রেকর্ড বুনিয়াদে সম্পাদিত ও রেজিস্ট্রিকৃত দলিল বুনিয়াদে 1 নম্বর বিবাদী নালিশ সম্পত্তির মালিক বলিয়া দাবি করিতেছেন, ইহা আমার জ্ঞান মতে সত্য। উক্ত দলিল বুনিয়াদে 1 নম্বর বিবাদী কোনরূপ কোনো নালিশ সম্পত্তির মালিক ও দখলিকার হইতে পারেন না বা মালিক হইবার কোনো কারণ নাই। তজ্জন্যে 1 নম্বর বিবাদী যাহাতে বাদীগণের নালিশি সম্পত্তি ভোগ দখলে কোনরূপ কোনো বাধা বিঘ্ন সৃষ্টি করিতে না পারেন, তজ্জন্য চিরস্থায়ী নিষেধাজ্ঞার আদেশ প্রার্থনা করেন, ইহা আমার জ্ঞান মতো সত্য। বাদীগণ এই মকদ্দমা দায়ের করিয়া আর্জির প্রার্থনা মতো প্রতিকার প্রার্থনা করিতেছেন, ইহা আমার জ্ঞান মতো সত্য। 1 নম্বর বিবাদী পক্ষে দাখিলা জবাবের যাবতীয় বিষয় সর্বব মিথ্যা ও কল্পনাপ্রসূত এবং সকল বিষয় দৃঢ়ভাবে অঙ্গীকার করিতেছি, ইহা আমার জ্ঞান মতো সত্য। When dispossessed, nowhere it has been stated. How dispossessed, it has not been stated. The manner of disposition, that has not been stated.
My position came from 1931.
But my position came from 1931, when the unregistered deed of gift was given to me, given to my predecessor.
Your name appeared in the RS record.
And
of
it
right.
was affirmed in the RS. And that has been exhibited. And in a 44(1)(a) case, that has been proved. That has been rejected, no appeal has been filed. So the possession since 1931 is proved.
On your behalf, did you adduce any document in regard to that?
Yes,
On your behalf, what did you adduce?
like a gift deed
Give
of 1931 exhibit. Kindly see the exhibit page.
exhibit গুলো দিন তো।
মানে page, kindly see page 28.
Exhibit গুলো দিন।
হ্যাঁ।
Exhibit গুলো দিন, exhibit গুলো দিন।
It was not valid to manner during his lifetime.
Exhibit গুলো দিন। এক্সিবিট থাকবে টাইটেল সুটের রেকর্ডে।
No, my junior is there. May I take a water, water.
Yes, yes,
My junior is there. I'm just one.
yes, yes.
Page 28. Kindly page 28.
টাইটেল সুটের রেকর্ড বার করেছেন, এবার এক্সিবিটে যান। না না না, she has to learn. সাক্ষী পেয়েছেন, এভিডেন্স পেয়েছেন? এভিডেন্সের পরে বা আগে কোথাও একটা দেখুন রয়েছে, এক্সিবিট লিস্ট থাকবে, এক্সিবিট 1 এক্সিবিট 2 থাকবে প্লেন্টিফের হয়ে, আর এক্সিবিট 1 2 আছে, ঠিক আছে, তার এক্সিবিট 1 2 আছে ইংলিশে, 1 2 আছে, তো এটা যে প্লেন্টিফের হয়, ঠিক আছে। আর এক্সিবিট এ বি দেখুন আছে কিনা, আছে তো, দিন। এক্সিবিট এ বি হচ্ছে ডিপেন্ডেন্টদের। Mr. Ghosh, you are referring to
Exhibit A.
exhibit E.
A.
A.
Personal calculation exhibit A. The unregistered deed of gift.
Yes.
This deed was executed on the 22nd Falgun 1338 BS, that corresponding to 5th March 1932. But even if we considered that the unregistered gift deed does not confer any title, it's conferred possession, because I am in possession since 1932, and this possession was never challenged by the predecessor in interest, that is Umapada, that is the plaintiff's father. He was one of the signatories. If you also kindly see, Grohita Srimati Subhashini Dasi, my maternal grandmother. Data, এক নম্বর
Where in-
ভোলানাথ দত্ত,
Where from you are getting? Which line? First page, which line?
kindly see this, the Grohita,
Oh, acha,
the top.
middle portion there is vacant. Acha,
The
Grohita.
signatures are there. Signatures and shows are there.
Grohita is Srimati Subhashini
The
Dasi,
maternal
and
grandmother of the
Data is Bholanath Dotto.
ভোলানাথ দত্ত, ইষ্টপদ দত্ত, জাতি, and Umapada.
Yes, three brothers.
Three brothers. But kindly see the schedule. What is the area of the property which has been gifted? 1 shoto, 1 decimal.
Place it.
The
Jela,
Jela, Subat Thana, I cannot read in such a Kotian number 1102, Dag number 6296, jail number 102, Uttor Simana Daktirikar, Sarada Prasad, Sreni Bari, Ghor, Jomir Poriman, 1 decimal, 1 shoto. But kindly see the area of land. You'll also will understand from the area of land itself the intention of the donor. The donor is intention to give shelter to their sister. That is their intention.
One decimal of land.
And it is of no, my advice.
ঠিক আছে, না, না, বলো, 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 বলো।
And it is of 22nd Falgun 1338 BS, that is 5th March 1932.
দেখুন, ট্রান্সফার প্রপার্টি অ্যাক্ট আছে, রেজিস্ট্রেশন অ্যাক্ট আছে, রেজিস্ট্রেশন অ্যাক্ট আর ট্রান্সফার প্রপার্টি অ্যাক্ট।
Live.
রেজিস্ট্রেশন অ্যাক্ট। Mr. Ghosh, section 123.
Yes.
When has the Transfer of Property Act come into force?
Not before 1882.
1882.
At that time,
So-
that road was there. There is no dispute.
There is no dispute. Now, section
The
123.
purpose of making a gift of immovable property, the transfer must be effected by a registered instrument signed by or on behalf of the donor and attested by at least 2 witnesses. This is absolutely right.
There is no dispute as
No
to-
dispute on that. This document is unregistered. But even if it, what I'm trying to submit to your
Now,
lordship,
can you place the? It's only one page document. Can you place the entire document?
so the second page is there.
Combining 2 pages, one page document. Half of the first page and half of the second page. But it will take time of 4 pages.
Yes.
Can you place it?
Yes, yes, I
Yes.
can keep it.
Place. No.
Place,
Acha,
Baba.
huh? Now, Uri Baba.
I can't even read the language. Well, very tough. I should be candid.
No, today we will conclude.
Yes, yes. I'll
But-
I'll file a copy. I'll file a copy.
But
Right copy.
today we will conclude.
Microscopic,
No, not microscopic. It is.
not legible.
It is, yes, the handwriting is.
যেহেতু আগামী আমাদের জ্যেষ্ঠ সহধরা ভগ্নী বাল্যকাল হইতে আমাদের প্রতি যথেষ্ট স্নেহ মমতা ও সেবা শুশ্রূষা করিয়া আসিতেছেন, স্বর্গীয় পিতা মহাশয়কে জীবিত কালে তাহার ও আপনার সেবা শুশ্রূষায় তত্ত্ব অধীন লইয়াছে। নানা বিষয়ে আপনি সক্ষম সমূহ করিয়া পাইয়া আমরাও আমাদের প্রতি প্রীতি ও প্রফুল্ল আছি। অধুনস্থ প্রয়াগ সহকারী সহকারী আমাদের উপকার করিয়া আসতেছেন। তদ নিকট বাদে অল্পনা সর্বক্ষণ কামন করিতেছে। আপনার বসবাসের স্থানের অভাব থাকায় বর্তমান ও জন্য আপনার উপরোক্ত অর্ডারে মোতায়ের জন্য আপনার সন্তানাদি কথা চিন্তিত পুনরুদ্ধার করিয়া স্বর্গীয় পিতামহাশয়ের মৃত্যুকালীন অনুরোধ রক্ষার জন্য আমরা ভগিনীকৃত নিম্ন তপশীল হইতেছি স্থিতিবান বস্তুবাটি সমাধি আনন্দময়ী একমত ডিসেম্বর বস্তুবাটি তদাস্থিরে করিয়া 2 কুঠুরি ও দক্ষিণ দিকে মোট তাহার স্থান আনুমানিক 25 টাকার উল্লেখিত বস্তুবাটি আমরা আপনার অর্থ দানপত্রের দ্বারা 3 ভাতা আপনার সর্বত্র ত্যাগ করিয়ার জন্য দান করিলাম এবং এই দানপত্র লিখিয়া দিয়ে অঙ্গীকার করিতেছি আপনার অধ্যকার তারিখ হইতে ও সম্পত্তির দান বিক্রয় বন্ধক বহুবিধ হস্তান্তরের মালিক হইয়া নিম্ন তপশিলি বর্ণিত জমিদার গণের রাজস্ব যথা নিয়মে যথাস্থানে স্বনামে বা নিজ নামে বা ভারী স্থানে আদায় দিয়া দখিলদারি পূর্বক আমাদের শতবান দিয়া পুত্র পৌত্রাদি ওয়ারিশ শোধ করিয়া সাহেব পরম সুখে ভোগ দখল করিতে থাকিবেন। কস্মিন কালে তাহার তো আমরা নিকট ওয়ারিশগণ সুফল ব্যক্তি কোন প্রকার দাবি করিয়া আপত্তি করিয়া গৃহ সর্বস্থান ভাবে সম্পূর্ণরূপে সত্যবান দাখিলদার থাকিবেন। The property is about 1 decimal and the intention is very clear, but maybe the gift deed is not registered, but a registered gift deed may not convert the title, may not transfer the title, but an unregistered gift deed may taken as the intention of the donor that they wants to Once their sister may reside there in a 1 decimal land, thereby constructing a house. And they have given the position in 1931, 1932, 5th March 1932. And this position was not affirmed by RS record of right. The RS record of right was created. If you also kindly see the exhibit E,
Mr. Ghosh, how did you get the date?
not
From?
written in the written in that.
No,
You also
obviously it will be written in the date at the end portion, but that portion is
written in that.
not visible here.
No, no, I've seen, I've marked. Kindly see the last line, the second page, last line. The 22 Falgun 1930, 1338 BS.
Mr. Ghosh, which portion?
Just above the Tokushil. Just
Above the top, yes, just above the top sheet.
the 22 Falgun 1332. It's very original.
Exactly. It has been mentioned in the portion which has been folded, and that is not visible. দিয়ে দিন ওই যে folding এর জায়গা
Yes, but it's a 22 Falgun is it can show 22 Falgun. Thereafter it has folded. Thereafter it has folded. 22 Falgun. That's an admitted 22 Falgun 1338 BS, corresponding to 5th March 1931. But subsequently, this position was affirmed at the time of preparation of RS record of right.
yes.
At the time of preparation of RS record. People also kindly see exhibit E, but after preparation of RS record of right, my predecessor's name was recorded as Rayot. That was challenged.
And exhibit B is the second deed of gift,
Second.
registered deed of gift.
See, these are the lots of the different information slips and the lots of the document.
Information slip.
Yes, the document relating to lots of the LR, document relating to RS.
D.
Well, kindly come to E.
Yes, E.
But kindly see, this is of 1957.
Under the Estate Acquisition Act.
Yes, estate acquisition. After preparation of RS record of right in the name of my predecessor, an objection was filed under section 44(1) of the Estate Acquisition Act before the revenue officer. That is page 44. Number a hearing was conducted. Number an order has been passed.
Yes.
An order has been passed, and my predecessor's names recorded as Rayat was affirmed. But this was never challenged.
By this person.
This was never challenged either by the predecessor of the plaintiff or my other brothers. So my position over the suit property generated from my maternal grandmother, who obtained the same admittedly by way of an unregistered gift deed, which may not confer a title, but definitely my possession has been admitted by way of that document, and which was subsequently affirmed in RS record of right by preparation of RS record of right, which was challenged under 44(1), affirmed by the revenue officer and not challenged thereafter. So while filing this suit for declaration and recovery of possession, the plaintiff very knowingly is not
Mr. Ghosh,
mine.
can a revenue officer decide the right title interest?
No, this is not. He has declared the record. Regarding the position, he has not said that I'm the owner or I'm not the owner. The recording that I'm a riayat or not, that may be wrong, but my position cannot go. But a recording in a record of rights,
From all the documents, you
what I
intend to
tried to substantiate
that
is that my position is
since
uninterrupted.
1931, you are in possession.
My position is uninterrupted. So well, the plaintiff intentionally, while drafting the suit, the plaint initially did not say for any recovery of position. Subsequently, when amended, he intentionally and very knowingly did not disclose when he has disposed, because his position was never there. My position in the suit property was generated from my maternal grandmother since 1931 till today, uninterruptedly, and in the knowledge of the plaintiffs and their predecessors, because an application was filed before the revenue officer for correction of record of right of my predecessor as a right. So they don't know. So that is their knowledge. So my position is uninterrupted, hostile to the plaintiff's predecessor and the plaintiffs, and the suit file for recovery of position is completely barred by matter limitation, because this does not disclose the cause of action. But firstly, but secondly, another thing is that
Counsel, substantial questions of law.
the substantial question of law is only on the point whether the unregistered deed can confer a title over the property on subject to collection.
In which page is the substantial question of law?
Second,
Part two. Part two.
That is part one.
Part one.
Page 38.
Yes.
But,
Whether the learned courts below have erred in law in holding that
the unregistered deed of gift is valid as per provision of section 25 of Indian Contract Act, even though the said deed was unregistered, whether the court have clearly erred in law in arriving at a finding that since the unregistered deed of gift was never challenged, Exhibit B would bear a title by reason of Exhibit B, the defendant number 1 become the owner of the property in question. So either of the case, my respectful submission is that either of the case, if your lordship hold the substantial question of law against me, that does not ipso facto get an order of recovery of funds, because suit is itself barred under section 64 and 65 of the Limitation Act. Because my position is uninterrupted since 1931 in the plaint, they have never discloses when they have dispossessed, because their disposition is very vital date for institution of suit as a cause of action. The lack of registration does not cannot be used by the plaintiff to evict me as the lawful successor of my predecessor. But it may be, if you hold that these documents are not valid, these documents does not confer title in my favor or in favor of my predecessor, does not ipso facto give an order, give and decree for recovery of position, unless I can prove that position is uninterrupted and hostile. But firstly, I tried to substantiate through the first deed of gift, unregistered deed of gifts, 22nd Falgun 1338 PS. Secondly, I have showed to your lordship the arrest record of right, which was challenged and affirmed by the revenue officer, which was not challenged or never any suit was filed at that relevant point of time, the predecessors of the plaintiff. And thirdly, my lord, in the plaint itself, even after amendment, they did not disclose when they have dispossessed. And the manner of disposition. Number
yes.
But this is my substance of my subject to my learned সিনিয়র ফ্রেন্ড একটু জানতেন কি
হুম।
আপনার এই মাইনার এটা
হ্যাঁ,
একটু কম দেখতে
হ্যাঁ। হুম, এটা দেখেন পাল্টা। Well, in a suit for recovery of first position, one of the essential condition is I have already submitted before your lordships. Entitlement, manner of entitlement, specifies on the date and mode of disposition, and conversely, what is the nature of possession claimed by the defendant. হ্যাঁ বলছি, সিভিল অ্যাপিল নাম্বার 8451। হ্যাঁ দেবো 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 দিয়ে দেবো, দিয়ে দেবো আপনাকে। এক্ষুনি দিচ্ছি, এক্ষুনি 8451 of
Yes, unreported citations, a copy is to be provided.
of course, immediately.
In respect of reported, you can mention the.
Para 11 and 12, my lord. I'm the suit is one of para 11, my lord.
Yes,
The suit is one for perpetual injunction, alternatively for recovery of possession. The plaintiff, for the relief of perpetual injunction, along with prima facie case, balance of convenience and irreparable loss, must also prove the actual possession of the suit schedule on the date of filing of the suit. Must also prove the actual possession of the suit schedule on the date of filing of the suit. It is axiomatic that possession on the date of filing the suit is an essential requisite for granting perpetual injunction. The findings recorded are that the plaintiff was not in possession of the suit schedule property. In a suit for recovery of possession, the essential conditions is entitlement, manner of entitlement, specifies on the date and mode of disposition, and conversely, what is the nature of possession claimed by the defendant and how it is illegal. Admittedly, in the case in hand, these pleadings are completely absent. A few bits and pieces of evidence without pleading cannot be appreciated. Therefore, the relief is rightly rejected by reckoning the plea and proof placed by the plaintiff. To the same effect, Maria Margarita, etc., has been enumerated.
as laid down, paragraph 67, 69, 70,
Yes,
75 and
77,
77.
12. my lord. Now, paragraph 12. my lord.
Paragraph 12.
Adverting to the alternative relief of recovery of possession, after perusing the plaint, we record that the plaint is benefit of the required details. 1 minute, my lord. Required details on the alleged date of disposition and the basis on which recovery of possession is prayed for. In the absence of material pleadings and evidence, the suit of plaintiff is rightly dismissed.
এভিডেন্সটা দেখো, এভিডেন্সটা দেখো, ওদের ওদের সাক্ষীটা দেখো, ওদের সাক্ষীটা দেখো, ওদের সাক্ষীটা চিপটা দেখো, না দেখাও ওটা আবার ক্রসটা দেখো।
Lordship, kindly come to chief and cross
Of
of the PW1. That is in part 2.
চিফে কোথাও কিন্তু বলেন
yes,
In the chief, I have already read. Nowhere it was stated.
ম্যাসকুলেট করে
referring to cross examination dated.
12, page 12.
Yes.
Chief.
No, you have placed the chief.
I have already placed the chief. Nowhere it has been stated. The cross also, Lordship, kindly see. Further examination chief of PW in chief to the affidavit in chief today. The plaintiff number 1 is my husband. The plaintiff 2 is my sister-in-law. I depose therefore the plaintiffs. I am well accounted. I have filed on account in support of my case. I have filed the RSI, ROR, CS, ROR, CSR, CS, and one searching slip. These are respectively marked by exhibit 1, 2, 3, 4, 4A, and 5. I pray for decree in terms of prayer of the plaintiff. The claim of the defendant on basis of my deed is vague and false. Cross-examination by defendant number 1. I have never paid my rent to the government of West Bengal. The LRROR does not stand in our name. Lordship has got it. Umanad Datta is my father-in-law. He died before my marriage. Umanad Datta had 2 other brothers, namely Krishnapad Datta, Phanibhushan Datta, Bharanath Datta. I have seen Krishnapad Datta. Said 3 brothers had 1 sister, namely Phugani Nandan. Not a fact that Phugani Nandan was also known by Subhashini Datta. Then says, I cannot say whether Phugani Nandan was also known by Subhashini Dashi or not. Her husband was Bhupati brothers of Phugani Nandan. In the 1388 the suit property to Phugani Nandan, I am literate. Not a fact, since 1338 B.S. Phugani Nandan had been possessing the suit property alone about said Phugani Nandan. I have not seen Phugani Nandan had 2 daughters. They are namely Shobharani and Chandnibala. Shobharani was issueless. Chandnibala has 2 sons. I cannot say the name. Then says 1 son is namely Devnath. Not a fact, Subhashini Dasi had been residing in the suit property with to visit her father's house or was staying with her daughters. Not a fact, not a fact, not a fact. This then says the RSROR stands by my father-in-law, Umanath Datta. Not a fact, Shobharani had been possessing in the suit property. A mere license was given to Shobharani. Then says a mere license was given to Shobharani. Not a fact, Shobharani granted a permissive room. Not a fact, the RSROR stands by the name of Umanath Datta as licensee. In position column is correct recording. I have no paper or document to show that any partition ever took place in between the co-sharer. It was partitioned amicably. I do not know about any objection filed by Krishnapada and Bholanath at the time of RS operation. Not a fact that RSR was correctly prepared by the name of Shobharani. I have filed the suit in the year 1998. I know about the dispute in regard to a will as it was executed by Shobharani in favor of the defendant. When Shobharani died, I do not know if Shobharani was literate or not. Not a fact, Shobharani willfully and voluntarily executed indeed in favor of the defendant. By virtue, not a fact, Shobharani constructed a Pakka house in the suit property. Then says, Shobharani and myself raised a Pakka house, dwelling house in the suit property jointly. Not a fact, we have no position or title or interest in the suit property. Defendant is in exclusive position in the, not a fact, super virtue of the deed and by way of inheritance. My father's house is at Kandi. Not a fact, I used to reside in my father's house. My husband used to visit of Kotak and on. I am also looking after this case. Not a fact, our case is false one. Not a fact, we instituted this suit falsely. The LRROR stands by the name of the LRROR stands by the name of the defendant. Not a fact, the LRROR is correct in its recording. We have filed written objection against the recording of LRROR by the name of the defendant. I establish this said fact, not a fact.
No
So when
question, no
dispossessed,
question was put to her as regards to when.
because there is
dispossessed.
nothing said in the chief.
Yes.
Regarding adverse version, no question.
Malar,
Even that readings also. Even that evidence sheet.
the original owners of the suit property gifted the same to their sister by way of unregistered deed of gift dated 22nd Falgun. No, this is my argument.
Acha, acha. Learned counsel, any
The lack of registration cannot be used by the plaintiffs to evict her lawful successor. Year 2002, Supreme Court 960. এই কি রে বার পরপর বার করা আছে তো এটাই রিপোর্ট বলেন যে এয়ার 2002 Supreme Court 960.
Paragraph.
Para 11, 12, 13 and 14.
উনি যেটা চাইছেন হচ্ছে ট্রায়াল কোর্টের অর্ডার শিট চাইছেন, এখানে নেই, দেখতে পারেন। এখানে নেই, এখানে ডিপোজিশন আছে আর এক্সিবিট গুলো আছে, অন্য অন্য সামনের দিকে থাকবে। ইয়েস,
Paragraph 11, my lord.
প্যারাগ্রাফ 11।
Page 4. When the Transfer of Property Act was enacted, Section 53A did not find place in it. In the absence of Section 53A, there arose difference of opinion between various courts in India as regards the application of English doctrine of part performance of contract as it was then prevailing in England. Since there was a difference of opinion on question of the application of English equitable doctrine of part performance in various courts of India, the Government of India resolved to set up a special committee for making recommendations, amongst others, whether the British equitable doctrine of part performance be extended in India also. The special committee was of the view that an illiterate or ignorant buyer who had partly performed his part of contract required statutory protection. The committee was of the further view that where a transferee in good faith that lawful instrument, that is a written contract, would be executed by the transferor, takes possession over the property. The equity demanded that the transferee should not be treated as trespasser by the transferor, and subsequently evict him through process of law in the absence of lawful transfer instrument. The special committee also considered the question whether protection under the proposed Section 53A to a transferee would also be available, even if the period of limitation for bringing an action for specific performance of an agreement to sale has expired. On the said question, the committee was of the view that even after expiry of period of limitation, the relationship between the transferor and transferee remains the same as it was within the period of limitation, and therefore the possession over the property taken in part performance of an agreement is required to be protected, even if the period of limitation for bringing an action for specific performance has expired. Paragraph 12, my lord. The aforesaid recommendation of the special committee were accepted by the Government of India, as the same is well reflected in the aims and objects of Amending Act 1929, whereby Section 53A was inserted in the Act. And next paragraph, the special committees.
No manner of
আপনি বলবেন।
You will get the opportunity to give reply.
The special committee's report, which is reflected in the aims and objects of Amending Act 1929, shows that one of the purposes of enacting Section 53A was to provide protection to a transferee who in part performance of the contract had taken possession of the property, even if the limitation to bring a suit for specific performance has expired. In that view of the matter, Section 53A is required to be interpreted in the light of the recommendation of special committee's report and aims, objects contained in Amending Act 1929 of the Act, and especially when Section 53A itself does not put any restriction to plea taken in defense by a transferee to protect his position under Section 53A, even if the period of limitation to bring a suit for specific performance has expired. But there are certain conditions which are required to be fulfilled if a transferee wants to defend or protect his position under Section 53A of the Act. The necessary conditions are, let us kindly see the conditions. There must be a contract to transfer for consideration in immovable property. The contract must be in writing, signed by the transferor or by someone on his behalf. The writing must be in such words from which the terms necessary to construe the transfer can be ascertained. The transferee must in part performance of the contract take possession of the property or of any part thereof. The transferee must have done some act in furtherance of the contract, and the transferee must have performed or be willing to perform his part of the contract. My lord, so in my opinion, these conditions has been fulfilled. Well, there is a Privy Council judgment in that score, year 1919. এটা ওটা দিচ্ছিস কেন? ওটা না, দেখুন থার্ড পেজ দেখবে আছে এইটাতে। হ্যাঁ বলছি AR 1919 Privy Council 44 from Madras.
Paragraph.
Page 3,
Hmm.
46 alleged page
Acha.
Privy Council 46.
Mhm.
Just next paragraph, my lord.
Second last
It was not contended before the board that the above transactions effected a valid gift of the property to Durasani. For such a gift must under section 123 of the Transfer of Property Act be made by registered deed, nor having regard to section 91 of the Evidence Act, can the recitals in the petitions be used as evidence of a gift having been made. But the defendant's case is that Durasani, although she may have acquired no legal title under the transactions referred to, in fact, took possession of the property when it was transferred into her name and retained such possession until her death in December 1911, after which date it passed to the defendant as her successor. And accordingly, that the plaintiff's claim is barred by upwards of 12 years adverse position. The High Court upheld this contention, and their lordships, after considering the evidence, have arrived at the same conclusion. My lordships, can you see the last paragraph? This appeal has been dismissed. For the above reasons, and upon a review of the whole of the evidence, their lordships have arrived at the conclusion that the decision of the High Court is right. Last page, second two line, my lord. Moreover, the father of the lordships, can you see?
Yes.
The lordships already taken note of that. Even then, I have again reiterated. The father of the plaintiffs never challenged the possession of the Subhashini and her daughter Shobharani. Rather, accepted the order passed in the year 1957 by the revenue officer under APOTTI case number 2, which specifically shows that RSROR was prepared in the name of the Shobharani on the basis of her position and name of the father of the plaintiffs recorded as Onumoti Dong.
Exhibit E.
From Exhibit E, E1, E2, it is clear that the possession of the Shobharani is held uninterrupted, lawful possession for over 60 years based on the said instrument, and as such the defendant being her lawful successor cannot be evicted. And accordingly, the suit itself barred under section, Lordship, I have already said 64 and 65 of the Limitation Act. Lordship, kindly see. It office 2007.
Yes.
9 Supreme Court cases 641.
Paragraphs.
20, 19 and 22.
19, 20 and 22.
My lord.
Yes.
1 minute. Page 647, my lord.
Yes.
Only because the parties did not use the terminology which they should have, if so would not mean that the ingredients for satisfying the requirements of statute are absent. There cannot be any doubt whatsoever that having regard to the changes brought about by Article 64 and 65 of the Limitation Act 1963 vis-a-vis Article 142 and 144 of the Limitation Act 1900, the onus to prove adverse possession would be on the person who raises such a plea. It is also furthermore not in dispute that the possession of a co-sharer is presumed to be possession of the other co-sharers unless contrary is proved. Then, my lord, 2022. A plea of adverse possession or a plea of ouster would indisputably be governed by Article 14 and 65, Article 64 and 65 of the Limitation Act. Next, 22, my lord. Mere assertion of title by itself may not be sufficient unless the plaintiff proves animus possidendi. But the intention on the part of the plaintiff to possess the properties in suit exclusively and not for and on behalf of other co-sharers also is evident from the fact that the defendant appellants themselves had earlier filed 2 suits. Such suits were filed for partition. In those suits, the defendant appellants claimed themselves to be the co-owners of the plaintiff. A bare perusal of the judgments of the courts below clearly demonstrates that the plaintiff had even therein asserted hostile title, claiming ownership in himself. The claim of hostile title by the plaintiff over the sued land, therefore, was thus known to the appellants. They allowed the first suit to be dismissed in their 1977. Another suit was filed in their 1978, which again was dismissed in their 1984. It may be true, as has been contended on behalf of the appellants before the courts below, that a co-owner can bring about successive suits for partition as the cause of action, therefore would be continuous one. But it is equally well settled that pendency of a suit does not stop running of limitation. The very fact that the defendants, despite the purported entry made in the revenue settlement record in their 1953, allowed the plaintiff to possess the same exclusively and had not succeeded in their attempt to possess the properties in village Sanilu and or otherwise enjoy the useful thereof, clearly goes to show that even prior to institution of the said suit, the plaintiff respondent had been in hostile possession thereof. On the same line, my lord, 2004,
No. On the same issue, Learned Counsel
only
need not produce.
next judgment, last judgment, 2004 10 SCC 779. Only one paragraph.
Yes.
In the eye of the law, an owner would be deemed to be in possession of a property so long, paragraph 11, my lord.
Paragraph 11.
My lord, my lord. Page 785, my lord. Second
Yes.
paragraph, my lord.
In the eye of law.
In the eye of law, an owner would be deemed to be in possession of a property so long as there is no intuition. Non-use of the property by the owner, even for a long time, won't affect his title. But the position will be altered when another person takes possession of the property and asserts a right over it. Adverse possession is a hostile position by clearly asserting hostile title in denial of the title of the true owner. It is a well-settled principle that a party claiming adverse possession must prove that his position is nec vi nec calm nec piscario, that is peaceful, open, and continuous. So all the in my case, my lord, all have been covered. The possession must be adequate in. Yes, I have my written statement. I have already shown to your lordship. The
Peaceful.
possession must be adequate,
Peaceful, open, and continuous.
my lord. The possession must be adequate in continuity, in publicity, and in extent to show that their possession is adverse to the true owner, record of rights, etc. E series. It must start with a wrongful disposition of the rightful owner and be actual, visible, exclusive, hostile, and continue over the statutory period, etc. Physical fact of exclusive possession and the animus possidendi to hold as owner in exclusion to the actual owner are the most important factors that are to be accounted in cases of this nature. Plea of adverse possession is not a pure question of law, but a blended one of fact and law. Therefore, a person who claims adverse possession should show on what date he came into possession, what was the nature of his possession, whether the factum of possession was known to the other party, how long his possession has continued, and his possession was open and undisturbed.
Learned Counsel. So plea of adverse possession is not a pure question of law, but a blended one of fact and law. Therefore, a person who claims adverse possession should show on what date he came into possession,
1332.
what was the nature of his possession.
No,
what was the factum.
1332 on the basis of unregistered gift.
Hmm.
What was the nature of possession? Lordships kindly see, I have already possessed that. Whether the factum, I have already shown your lordships each and every every point has been covered by the defendant number one. His position was open and undisturbed. A person pleading adverse position has no equities in his favor. Since he is trying to defeat the rights of the true owner, it is for him to clearly plead and establish all facts necessary to establish his adverse positions. We have, in our written statement, by producing the documents, we have proved that we are in position. And since 1332. This is my respectful submission. And my learned friends, 3 points are there. Admittedly, an unregistered gift deed was executed by their brothers in favor of their sisters to the extent only 1 decimal of land on 22nd Falgun 1338 BS, corresponding to 5th March 1932. And since then, my
Corresponding to 5th March.
5th March 1932.
March.
And since then, my predecessor was in position. The said unregistered gift has never been challenged by the brothers of their successors, including the plaintiffs, on the grounds that it was manufactured, forged, or fraudulent. That has not been challenged in anywhere. So we are in exclusive possession since long. Moreover, the order passed in the year 1957 by the revenue officer under APOTTA case number 2 specifically shows that ROSR possession and name of the father of the plaintiffs recorded as Anumati Dong. And ultimately, they have not challenged it in appeal, the order passed by the revenue officer. And according to the position of the Sovarani is held uninterrupted, lawful possession for over 60 years based on the said instrument, and as such the defendant being her lawful successor cannot be evicted. This is my respectful submission. And about adverse position, I have covered all points and also stated in my written statement also.
In the written statement, is there any counterclaim as regards to
Nothing.
Position? Position?
adverse position?
Madam,
Counterclaim.
there was no counterclaim, but I have written my written statement.
In the contents you have mentioned.
I have, in my content, I have mentioned in each and every stages. Kindly see the written statement.
Yes, no. I have gone through.
My lord.
That's why this question is.
My lord, my lord. As I have get a chance to file written statement, I have stated in my written statement. If not, that then we can place it over counterclaim.
Yes, Mr. Doctor.
Learned senior friend, my lord,
My lord.
argued at length, but did not answer to my argument. The question of law. Nothing, no submission made in respect of when a deed is void. That deed is got no legal value in the eye of law. No submission to that effect. And my lord, apart from this, their admission is the best piece of evidence. My lord, you'll also kindly page 20 of the supplemented paper. I have pointed out, you'll also kindly mark once again.
Yes, 20. Part 1.
Supplemented paper, part 2.
Yes.
First cross-examination, you'll also find. Kindly you'll also
Page 20.
again mark, or possibly you'll also mark it. This is a fact that one Umabadat was the absolute owner of this property. They are admitting my title. And when they claimed adverse possession without without title of the owner, they cannot pay for any adverse possession. Adverse possession not against the stranger, true owner. That is the settled law. Now, Your Honor, kindly look into their admission that what they claim in their page 23.
So that's why you are placing the facts.
Just not fact, just regarding their claim of adverse possession.
Yes, page 23.
Have you also got it? I do not claim the shoot property as a trespasser or forceful possessor. Last line.
Page 23.
Page 23, last line. I do not claim.
Yes, I do not claim the suit property as trespasser or forceful possession.
Now, this argument is meaningless. Your Lordship will not take into cognizance any of the argument. And on the basis of their alleged claim, all in the written statement, in the evidence, on the basis of the unregistered gift deed. There is void of initio. And the judgments cited are not at all applicable in our case. And in the cross-examination, in the plaint, in the evidence, we have stated the granted license, eviction of a licensee. At any time, at any moment, I can revoke and I can pay for. And when my right of infringement is affected, there is this cause of action.
Why you have not filed revocation of license?
Mr. Datta, it is not your case that you have paid for eviction of license.
No.
If you say so.
I have stated in my plaint that I granted license, I allowed them to stay. And when they did not vacate, and ultimately, I initially filed suit for declaration and permanent injunction, when they forcibly trying to oust me, and part of the property ousted, then we paid for recovery of cash possession. Against the trespasser, when license automatically revoked, that when
yes,
my title has been perfect. My title is perfect. My title is proved as per their admission also. And all the judgments are not
relevant
for the purpose. And with regard to the limitation, Your Lordship kindly look into their written statement. No issue has been framed. No prayer, no affirmation in the written statement. Your Lordship kindly look into page 7 to 10. Your Lordship will not find. So barred by law of limitation. No issue has been framed. No substantial question has been framed. There is no affirmation in the written statement. Paragraph page 7, Your Lordship can look into. Paragraph 1, 2, 3. Not maintainable. Waiver, stoppable acquisitions, and under section 34.
In the additional written statement, also
Nothing.
not mentioned.
And so that's why, my lord, in the trial court judgment, Your Lordship, and appeal court judgment, Your Lordship find the issues framed. Page 4 of the part 1. There is no issue framed regarding limitation. So this argument is not tenable, or he ought not to be allowed Rather, he ought not to be allowed to make such submission. Beyond pleadings, beyond substantial question of law, you are also hearing the second appeal. Beyond substantial question of law, and my lord, I shall give one answer to this regarding substantial question of law. A substantial question has been framed regarding section 25 of the Indian Contract Act. You will also kindly look into section 25 of the Indian Contract Act.
Contract Act, Contract Act,
Section 25.
Contract Act.
The power to fail successful was not the law, which found necessary for termination of that. What is the power to fail?
What has every power to formulate?
Shall I hand over one book, my lord?
One minute. Hold on. If not available, then
My lord, you also kindly. In the morning, I have participated. I have forgotten to bring.
Beer Act.
I have forgotten to bring. That's why in the morning purchased it.
Yes.
Agreement without consideration void unless it is writing and registered. I will not eat anything more. Section 21 substantial question has been framed. The substantial question law is in my favor. This document, this initial document is void. Is nullity in the eye of law. Subsequent all acts are void. Their entire claim based on unregistered document. This is the only reply to your lordship. Every argument, each and every argument as submitted by my learned friend is not sustainable in the eye of law. As initial document is void, their entire pleadings based on unregistered document. So all other things are nullity in the eye of law. And you also knows that in the service jurisprudence, initial appointment is bad, everything is bad.
Why service jurisprudence is coming here?
No. Initial appointment is bad, everything is bad.
So
that is
complete.
And from the pleadings, from the evidence, they have argued beyond the substantial question of law, and they have argued beyond their pleadings. And my lord, shall I not file any notes of argument? If you lordship direct, I can file short notes of argument. No, not required.
Need not.
I have argued at a length, they have argued at a length.
If your lordship asked us to give written statement, we will place it immediately.
Written notes. Written notes are ready. Let a copy be handed over to them. Mr. Datta, can you provide it within Friday? Within Friday. Ought to have been made ready. But there won't be any date for that.
No.
You
I will
provide it
just
to
hand over.
hand over to the court
I will
officer.
hand over the typed copy of the gift.
Yes. It will better.
I'll hand over to you.
Within Friday.
Within Friday.
আমি ফ্রাইডের মধ্যে আমি দেবো তোরে উত্তরটা দেবো আমাকে আজকে না দিলে আমি দেবো কথা
কোনটা আমি দিয়ে দিচ্ছি আপনাকে আমাকে এক্ষুনি দিয়ে
No,
দিচ্ছি
he will provide the typed copy of that unregistered deed of deed.
আপনাকে ওটা দিয়ে দিচ্ছে
আমার কাছে কোথায় রাখলাম হারালাম
Learned counsel representing the
আমি আরে জেরক্স করে দিয়ে দিচ্ছি
representing the respondents commences his submission, and after exhaustive submission has concluded the same. Full stop. Senior counsel in reply, the senior counsel representing the appellants have also concluded. Full stop. Verbal submission concluded. Reserved for judgment.
মানে আমি হ্যান্ড ওভারিং না তো দিয়ে দিল
মানে we are very grateful for patience hearing.
There will be patience hearing, but cooperation from that end is required. Yes,
But
And
we
but
are
everything within Friday,
within 5.
written notes in bullet form.
এটা একটু চর্চা একটু বলো না, এই রেকর্ডটা আমরা একটু দেখবো, লিখে নেবো, আমাদের কাছে রেকর্ডটা পাওয়া যাচ্ছে না। এই
কোনটা?
মামলাটা, এই মামলাটা
Next,
সেটা কোনটা?
হরিপদ সাহা পরে আছে যেটা।
My lord, my lord, only one thing, my
one
lord.
minute. Mr. Dotto, you are referring to that, not referring, you are intending to see the trial court order sheet. The order sheet is not there.
I am not finding. And trial court order is required, my lord, your lordship will find the
শুনুন ট্রায়াল কোর্টের অর্ডার শিট মানে আপনি টাইটেল অ্যাপিলের
Number আছে আজকে।
অর্ডার শিট আছে, ওই রকমই হবে ট্রায়াল কোর্টের। যদি না
ওটা টাইটেল আপনি লিখিত বের করেছেন, টাইটেল
টাইটেল একদম ওরমই হবে, ঠিক আছে, ট্রায়াল কোর্টের পিএস বলে থাকবে।
order sheet এর
যদি
জজটা
না
বের
থাকে
করে
যদি না থাকে তাহলে সেকেন্ড অ্যাপিলে যে সেকশন আছে থেকে পাঠিয়ে বলবেন, বলে আজকের মধ্যেই রেকর্ডটা পাঠিয়ে দেবেন চেম্বারে, ঠিক আছে।
My lord, only one prayer.
kindly record the order dated 3/5/2005 and order dated 28th of August 2002.
Order dated 3/5, no, first one 3/5,
2005
2005,
and order dated 28th of August 2002.
28th of August 2002.
These two order, your lordship, and another order, my lord, 15th of July 2002.
অ্যামেন্ডমেন্ট হয়েছে 2004-এ।
2004 হচ্ছে।
What will reveal from
Regarding amendment.
hmm,
Order 6 Rule 17 regarding amendment.
was filed probably on
The order will
15th of
reflect-
July, 15th of July, allowed on 28th of August.
If no, amended first, my lord, addition of pro forma dependent 4, that is allowed on 15th of July 2002.
আচ্ছা,
Pro forma dependent number 4,
Hmm.
added, application filed for addition of party.
addition of party.
Next, my lord,
Order
amendment,
1 Rule 10(2).
amendment of, my lord, recovery of first possession on 28th of August 2002.
Oh, that was heard of and disposed on 3rd of May 2005.
Amended by order dated,
By the order.
by order dated. Next, my lord,
এটা কথা হ্যাঁ,
next, my
এটা
lord, you
কত
have to
নম্বর
find
আমি বলে দিই।
paragraph 5 amended by order dated 3/5/2005.
শুনুন
These
না,
3 orders are required.
150,
একটু আনাবেন, ডাকিয়ে আমি
159
অর্ডার শিটটা ট্রায়াল কোর্টে।
And from this order, you lordship will find regarding the amendment.
Only one prayer before your lordships regarding another other matter.
Hmm.
169 we will go through the record if your lordships permit.
Yes, yes.
নোট করতে হবে।
Item number 169.
And we will have to take in some notes also from there because it's a very Long pending.
After the court hours.
up to the court. Yes, yes.
169, item number 169, ওনারা দেবেন, ওনারা নোট নেবেন, ঠিক আছে।
আর একটা কোন ম্যাটার আছে 10 আছে না?
নিন, next.
10 মানে I am praying not today in item
no.
number 10.
When the matter will be called, let there be someone, yes, let there be someone to mention.
Highly obliged, my lord. Grateful we are, my lord. We are grateful.
Next.
Item number 2,
Lord, I am for the petitioner.
That K,
Yes.
uh,
My Lord,
do you have any answer?
yes, my Lord. Today, I think, my Lord, I could satisfy your Lordship, Lord. Lord, my application under Order 1, Rule 10 was rejected.
1 minute. ওই কি বলে এখানে ওই
The schedule of the
One minute.
property,
ওই ডিডটা কোথায় গেল? দেখুন এসে ডিড আছে,
supplementary affidavit is there. my Lord.
সাপ্লিমেন্টারি এফিডেভিট আছে। আচ্ছা, সাপ্লিমেন্টারি এফিডেভিট, ইয়েস, পেয়েছি, ছেড়ে দিন।
Now, my Lord, head 3/103,
You are
oblique
referring,
K,
you are referring to which page?
my Lord, first, your Lordship, is there plaint, but at page 20.
my lord, my revisional application,
Yes,
page
yes.
20.
Schedule, you are placing the
Schedule.
schedule.
Schedule, my lord,
A, the entire,
yes, my lord, he is asking for situated at KMC premises number Z3/103 Jeliapara Road. Lordship, fine.
103,
Now, my lord,
Jeliapara Road.
now, my lord, my deed contains, your lordship kindly come to supplementary affidavit,
Yes.
page 14. Page 14,
Page 14.
the schedule above referred to,
Hmm.
my lord, 1, 2, 3, 4, 5, 6 line, my lord. Garden Ridge Municipality premises number Z3/103/K.
Yes,
This does not match with that.
yes.
Now, my lord,
That
once,
was the question.
yes, my lord, that once I invited your lordship to page 18 of the
Original
my
application. Yes.
at paragraph 12.
Hmm.
That the cause of action for the instant suit had arisen firstly on 21st January 2022, when for the first time the plaintiff came to know about the alleged deed of gift as stated above, and thereafter from being then at premises number Z3/103/K, Jeliapara Road. Beside that, my lord, I shall take up very less time to your lordship. Your lordship kindly see one document I have found that we are the co-owner.
Learned Counsel,
My lord.
at this juncture,
My lord.
no new document can be taken into consideration.
But I have
Those,
found one.
those documents upon which you have relied upon before the trial court, those will be taken into consideration. So
But
now,
to
learned,
substantiate my case,
now learned counsel, on which ground the trial court rejected your application under
Yeah.
Order 1 Rule 10(2)?
the ground was only
Place,
the name.
place that.
Yes, my lord, that page. Uh, Lord, my lord, may I read?
Yes.
My lord, I am reading only. Learned word for the petitioner in the petition under Order 1 Rule 10(2) of CPC has stated that plaintiff has filed an instant suit for declaration and injunction against the defendant, but not included the petitioner as a party to the suit, even they have a portion of the land measuring 15 chetaks 30 square foot with a structure within the undivided suit property. The petitioner claiming himself to be co-sharer and jointly possessing the portion of the undivided suit property, which he obtained by virtue of deed of gift dated 2/8/2005, executed by the plaintiff of the instant suit. The petitioner is in possession and muted his name in the KMC record and enjoy the same by paying taxes with the KMC. That I have shown in the before the learned court below. I have shown.
No. What are the annexures herein?
No, my lord, I have not annexed here. My lord,
in the supplementary affidavit?
Yes, my lord, supplementary affidavit.
Learned counsel, what you had relied upon before the trial court at the time of hearing of the Order 1 Rule 10(2) application,
yes,
you will have to annex herein also. Otherwise, how can this court go through those documents?
Yes. I have not annexed that. Now, Lord, the petitioner is in possession and muted his name in the KMC record and enjoy the same by paying taxes with the KMC. The petitioner thus prayed for adding him as a party defendant and he is willing to contest the suit. Learned advocate for the plaintiff by filing WO raised vehement objection and submits that the deed of gift annexed with the petition bears name of the Muhammad Hamija as executant, but the name of the plaintiff here is Muhammad Hamja. Hamzda, Hamizda.
Here, in the deed, it is Muhammad Hamiza, son of Muhammad Maqbul.
Yes.
1 minute. And in the plaint, it is Muhammad Hamza, son of late Muhammad Maqbul Ansari.
Yes, my
Hmm.
lord.
Hmm.
No, my lord. Learned advocate further submits that the petitioner claim is fake, since the registered deed bearing number 3098/2005 stands in the name of different person, not in the name of petitioner.
Hmm.
Learned advocate further submits that had the petitioner be
1
added
minute.
as a party.
1 minute, 1 minute.
Yes.
Dhoni in the Dhoni is Muhammad Sams Badr Razvi,
Rajvi.
and
Donor is
1 minute. No, where is the application under Order 1 Rule 10(2)? Application
my
under
lord,
Order 1 Rule 10(2).
application under Order 1 Rule 10(2) is at page 24.
24. Muhammad
Hamza.
Muhammad Sams Badr Razvi. Yes.
Yes, my lord.
Son of late Muhammad Maqbul. Son of Muhammad Maqbul. Acha.
No, my lord.
Hmm.
Learned advocate further submits that had the petitioner be added as a party as prayed for by virtue of this deed of gift, the
So,
cause of
Learned
action,
Counsel, what is the relation between you and Muhammad
Hamza.
Hamza, the donor
We are both brother, my lord.
brothers? ठीक है, sir.
The plaintiff would change. Learned advocate thereby virtually denying the execution of the said deed of gift.
Hmm.
Now, my lord, although the defendant did not participate in the hearing of the instant petition, but in his written W, defendant number 1 raising objection by stating that the petitioner is not a necessary party to the suit, and the suit can be effectively adjudicated between the existing parties alone and without presence of the petitioner. That the
The
defendant number,
suit is for
my lord, the
uh,
plaintiff
declaration
says that,
the
my lord,
plaintiff is
the deed of gift,
absolute owner of A scheduled property to the exclusion of the defendant against the defendant in favor of the plaintiff. A decree for declaration be passed declaring the deed of gift dated 24/7/2008. This one is that deed 24/7/2008.
no, my deed is up 2005.
2005. So whose deed is this one? 24/7/2008 of somebody else.
Somebody else, my lord.
Entered in city volume. So you are claiming to be one of the co-sharers in respect of the said
my lord.
property by virtue of the deed of gift.
Deed of gift. And our
being number 3098.
Yes, my lord, in the KMC, our name has been recorded. All names have been recorded.
Nil. Nil. The learned counsel representing the petitioner submits that through the impugned order dated 8/12/2025, the learned trial judge has been pleased to reject the application filed by the petitioner herein on the ground that the name of the donor does not tally with the name of the donor being
Muhammad Hamza.
Muhammad Hamiza, name of the donor, namely Muhammad Hamiza, do not tally with the name of the plaintiff, namely Muhammad Hamza. So according to you, the plaintiff was the donor.
Yes, my lord. Plaintiff was the donor. And my lord, one thing we, my lord,
He through that gift deed, he had gifted 15 chitaks of land to you.
My lord. My lord, one thing I want to, your lordship kindly come to page 15, my lord. More,
one minute. কি হলো? And name of the the name of the donor in the deed of gift dated 2nd of August 2005, by virtue of which the petitioner has been granted uh, 15 pitaks, 35 square feet of Bastu land, does not tally with the name of the plaintiff. ওর নাম দুটো বলে দিচ্ছ তো, একটাতে হামিজা HAMIZA আর ওটা হচ্ছে ডোনার, আর প্লেন্টিফ হচ্ছে মোহাম্মদ হামজা না HAMJA হামজা. Yes, Learned Counsel, anything more?
my lord, your lordship kindly come to once the deed gift. Deed gift at page 50.
15.
Yes, my lord.
Yes.
My lord, so far I know the signature. Your lordship kindly see signature is in Urdu. So far I know Urdu very well.
Learned
It is
Counsel,
Muhammad Hamza. It is Muhammad Hamza.
this court,
Now, my lord, I just
as regards to clarifying this signature,
My lord.
this court doesn't have the jurisdiction. That will be done before the trial court.
I want to say, my lord, that the name on the face of the record of the gift
That is not within the purview of this divisional
typographical
application.
mistake has been done.
Full stop. কি বললাম সেন্টেন্সটা কি বলেছি?
Dated 2nd August 2005, by virtue of which the petitioner has been granted 15 chatters, 35 square feet of Bastu land, does not tally with the name of the plaintiff, namely Muhammad Hamza.
ঠিক আছে, full stop. This being the issue, the present revisional application is admitted, full stop, as no copy of the revisional application has been served upon the opposite parties as yet. The petitioner is directed to serve copy of the revisional application upon the opposite parties when it will appear.
As your lordship is, my lord.
Within how many days you can serve?
At least 2 weeks, my lord.
At least 2 weeks. Let the matter appear. On 17th of September.
My
17th of September.
grateful to you, lordship.
Next.
Item number 3.
I'm for the petitioner.
I'm for the caveator opposite part.
This is appearing for the first time.
No, your lordship heard this matter on the last occasion and your lordship directed
On
it
last
to appear today. On Thursday morning.
On last Thursday.
No order was passed on that day?
No,
No.
because they sought for an adjournment.
Acha.
Yes.
Yes.
My lord, we have prepared this revision against an order by the learned trial court allowing an order 6/17 application, whereby the plaintiff sought to amend to include some facts regarding that the plaintiff number 1 and 2, they have got they partitioned the property, whereby I am a tenant, I am the defendant. They sought that sought to amend that the plaintiff number 1 and 2 got partitioned, and the tenanted property falls under the plaintiff number 1's property, and thereby the plaintiff number 1 seeks to transpose the defendant number plaintiff number 2 as the pro forma defendant, and also to amend the pleading regarding the same.
No. So the application under order 6/17.
Yes.
The plaintiffs intended to
To
whom?
not to add, to transpose the plaintiff number 2, and also to include some facts regarding their partitioning the property. And we have transpose the plaintiff number 2 as pro forma defendant.
No, plaintiff number 2 is a co-sharer.
Yes, a co-sharer.
Acha. In the
The
array of pro forma
pro forma
defendants.
defendant. Yes.
And in addition to that,
In addition to that,
you're challenging which one?
I am changing the order 6/17 application.
The entire
Yes. No, I am saying about the transposition.
transposition.
Yes.
Acha.
Uh,
So anything more to be submitted?
No, my lord. Regarding the transposition, I have raised the objection in the trial court also. And if your lordship kindly comes to the ordering portion of the impugned order, at the second page, last but second paragraph, the learned court holds that admittedly order 1 rule.
In addition to that, there was one application under order 1 rule 10 too.
No. There was
Admittedly, order 1 rule 10 CPC.
no.
provide-
That was our contention that the order application must be under order 1 rule 10. But the application was only filed under order 6/17, and they sought 2 reliefs under the same application. That is to transpose and to amend. And the court held that the admittedly
With
or
regards to amendment, actual amendment according to you.
Yes.
There is no challenge
no the
that
yes.
you are accepting.
Yes. But
Being a tenant in the suit property. Acha.
But my lord, I am
as regards to transposition, you are challenging.
yes.
That
In the
what not
schedule
to be-
portion of the amendment application, they also included the transposition matter also. That is
where is the application
yes.
under order 6/17?
And also page 30 is the application.
1-3.
No, 30. And the schedule is 32.
Yes.
Yes. Thereby, your lordship can found that in the cost title of the plaint, the name of the plaintiff number 2 be replaced and be inserted after the name of the defendants in page number 1 as pro forma defendant. We have objected to this, and we categorically raised our objection in our WO also, which we filed. But the learned trial court held that order 1 rule 10 CPC provides addition or alteration of the name and parties to the suit, whereas order 6/17 allows the court to amend pleadings, which includes amendment in cost title of the pleadings. We are objecting to this line only. And when such amendment is very much connected with the amendment of pleadings, then the specific contention that transposition of name of plaintiff number 2 as pro forma defendant number 4 is not barred under order 6/17. Now, I ask your lordship to kindly see the order 6 rule 2, if your lordship pleases. Thereby, we can under order 6 rule 2, it says that every pleading shall contain only a statement in a concise form of the material facts on which the party is pleading relies for his claim or defense, as the case may be. And the sub rule 2 says every pleading shall, when necessary, be divided into paragraphs numbered consecutively, each allegation being, so far as is convenient, contained in a separate paragraph. And the sub rule 3 says date, sums, numbers. Hereby, we nowhere can find that the cost title is also included in the pleading. But under order 7, rule 1, we can see that the plaint would include the cost title. But in the pleading section, we cannot find that the cost title also is included in the pleading. And they sought to amend the pleading, not the cost title.
There should not be any cost title.
Yes, there should be cost title, but the pleading section, the order 6 rule 2, as per the CPC, the cost title thing is not written, but the
So,
plaint includes.
Do you have any citation?
Yes, I have citations.
Stating that under order 6/17 transposition from plaintiff to pro forma defendant cannot be made.
Yes, I have citation that the order 1 rule. Yes.
What is the question?
Yes.
The question is, do you have any citation wherein it is mentioned that under order 6 rule 17, transposition from plaintiff to the array of pro forma defendant cannot be made?
Yes, if your lordship just sees the CPC in under order 23 rule 1A, it says that the transposition order 20, order 20 rule 1A, when transposition of defendants as plaintiffs may be permitted, where a suit is withdrawn or abandoned.
1 minute, Lord First. Order 23 rule
1A.
Rule 1A.
Yes. It
Yes.
says, my lord, where a suit is withdrawn or abandoned by a plaintiff under Rule 1 and a defendant applies to be transposed as a plaintiff under Rule 10 of Order 1, the court shall, in considering such application, have due regard to the question whether the applicant has a substantial question to be decided as against any of the other defendants. Here, the provision is regarding the defendant's transposition, but the same theory can be applied to the plaintiff's transposition as well. And the CPC itself prescribes that if there be any transposition, it must be under Order 1, Rule 10. And regarding this, I have some citations also, my lord. The Apex Court in 2020, volume 14, SCC, page 1, holds in paragraph number 8 that the law of procedure relating to the parties to a civil suit is essentially contained in Order 1 of the Code of Civil Procedure, dealing with various aspects concerning joinder, non-joinder, and misjoinder of parties. Rule 10 of Order 1 specifically provides for addition, deletion, and substitution of parties, and the proposition for transposition of a party from one status to another by its very nature inheres to Sub-Rule 2 of Order 1, Rule 10 CPC that reads as under. And thereby, it also has stated the Order 1, Rule 23A, Order 23, Rule 1A's provision also. And in the 11th paragraph, it also says that as per Rule 1A, but in the eventuality of plaintiff withdrawing the suit or abandoning his claim, a pro forma defendant who has a substantial question to be decided against the co-defendant is entitled to seek his transposition as plaintiff for determination of such question against the said co-defendant in the given suit itself. The very nature of provisions contained in Rule 1A, but leaves nothing to doubt that the powers of the court to grant such a prayer for transposition are very wide and could be exercised for effectual and comprehensive adjudication of all the matters in controversy in the suit. The basic requirement for exercise of powers under Rule 1A but would be to examine if the plaintiff is seeking to withdraw or to abandon his claim under Rule 1 of Order 23, and the defendant seeking transposition is having an interest in the subject matter of the suit and thereby a substantial question to be adjudicated against the other defendant. In such a situation, the pro forma defendant is to be allowed to continue with the same suit as plaintiff, thereby averting the likelihood of his right being defeated and also obviating the unnecessary multiplicity of proceeding. This is the Apex Court's view, and my lord, if the lordship permits.
So you are referring to 8 and 11.
Yes, 8 and 11. And my lord, another citation I have that is of High Court of Patna. It is cited in 2024 SCC Online, Patna 8327. Here also, the Honorable Court in paragraph number 7 says that though mere wrong mentioning of provision is not fatal to the cause of the respondents, but when there is
Where are you placing?
I am saying in order para 7.
Yes, paragraph 7.
Paragraph number 7.
Paragraph 7 starts with moreover the
Yes, the second sentence. Though mere wrong mentioning of provision is not fatal to the cause of the respondents, but where there is express provision in the code for substitution or transposition of parties, the learned trial court could not have exercised its inherent powers under section 151 of the code. And thereby, after Manilal Mohanlal Shah, there is also a Supreme Court judgment. It holds in the inverted section in the second sentence. We do not think that the inherent powers of the court could be invoked to circumvent the mandatory provisions of the code and relieve the purchasers of their obligation to make the deposit. That is the order in portion. And if your lordship comes to at the last paragraph, in the Ramkaran Das Radhavallabh judgment of the Supreme Court, at the last sentence of that page, we are unable to accept this contention. It has been observed by this court in Manohar Lal versus Hira Lal, year 1962, SC 527. At page 534, the inherent powers are to be exercised by the court in very exceptional circumstances for which the court lays down no procedure. And thereafter, one sentence after, express provision is thus made for setting aside a decree passed under Order 37, and hence, if a case does not come within the provisions of that rule, there is no scope to resort to Section 151 for setting aside such a decree. The court's view is that when there is specific provisions, it must be adhered to that provision only, and the court cannot exercise its inherent powers to decide with this. But in this impugned order itself, the court has deciphered that the amendment application also includes amendment in cause title of the pleading. And my lord, it is also a settled provision of law that whenever there are separate reliefs claimed, it must be sought under separate applications.
So according to you, whether is specific provision in that regard, 161 or 151 CPC or inherent power cannot be exercised.
Yes,
That is
not
the crux.
what I have learned. Right?
Anything more?
No.
Yes. So, my lord, what I see that his objection is regarding the caption of my application. That is that I filed the application under Order 6, Rule 17, read with 151 of the Code of Civil Procedure. Now, Lordship, it is now settled that, Lordship, caption of an application does not matter. The court has to see whether the court is capable of granting such type of relief. If it has got the power to grant such relief, it can grant. Lordship, in this regard, I am relying upon a judgment of this Honorable Court. Here, Lordship, this is reported in AIR 2009, Calcutta 160. Here, Lordship, at paragraph 13, a five judges bench of the Honorable Supreme Court has been quoted. Lordship, at paragraph 13, at page 161.
Yes.
May I read it out for your Lordship? It is also well settled that where a source of power exists, the exercise of such power is referable only to that source and not to some other source under which that power is exercised. The exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists, by reading together two provisions, whether statutory or constitutional, the order refers to only one of them, the validity of such order should be upheld by constituting as it is an order passed under both those provisions. Further, even the mention of a wrong provision or omission to mention the provision which contains the source of power will not invalidate an order where the source of power exists. So, Lordship, we have to see whether the court was capable of granting the relief as prayed for. So, under whatever provision, Lordship, whatever was the caption of my application, that doesn't matter. My Lord, kindly sees to the schedule. That is at page 32, Lordship. Lordship, the proposed amendment is a combined amendment, my lord. By the first, Lordship, I have prayed that since during the pendency of this suit, the plaintiff number 1 and plaintiff number 2 executed a deed of partition among themselves, and the suit property has fallen within the plaintiff number 1. So the plaintiff number 2 has to be added now as a pro forma defendant. So, Lordship, this is a combined application. While deciding this, the court has to see whether whatever prayer I have prayed, that it is capable of giving or not. And the learned trial judge was absolutely justified in passing the order impugned, holding that, Lordship, the court had the power and it was done. It will not change the nature and character of the suit, my lord. That is all.
Anything in reply?
My lord, no. Yes, what I have told,
to counter this citation which has been placed on behalf of the learned counsel representing the opposite party.
As per our contention, had there been such the view, had there been such view, then whatever applications may be under whatever orders or rules, and then conjointly any order can be passed. If that be the liberal view of the learned court be, there should be the adherence to the policies of the draftsman. As per my view.
There are two portions in paragraph 13.
Yes.
It is also well settled that where a source of power exists, the exercise of such power is referable only to that source and not to some other source, under which where that power exercised. The exercise of such power would be invalid and without jurisdiction. This portion goes against you. Second portion. Similarly, if a source of power exists by reading together two provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it is as an order passed under both those provisions. Mr. Chakraborty, where is the application?
Page
Is it
30.
annexed? Huh?
Page 30, madam.
30.
But they have filed only the order 6 rule 17, but had they filed under read with order 1 rule 10, then we could have said that
It's not necessary, my lord. Kindly even further, even the mention of a wrong provision or omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. So if the trial judge had that power, he can grant, even if I don't mention that.
transposition, the trial judge, he himself did not pass the order. It was only after their pleading he has pleaded.
Anything substantial to be submitted?
No.
My lord, may I pray for expeditious hearing of the
Suit of
2020?
22.
Without even any time frame also, just expeditious. Without any time frame. I leave it upon your lordship.
Name. Learned counsel representing the petitioners. The petitioner.
I am for the petitioner, one tenant.
Whole petitioner. Petitioner submits that to the impugned order dated 1/12/2025, passed by the learned trial judge, that is civil judge, senior division, suit for eviction.
Fourth court at Alipur.
Civil Judge Senior Division, 4th Court, Alipur, South 24 Parganas, in ejectment suit number 55 of 2022, has allowed an application seeking transposition of one of the plaintiffs to the category of pro forma defendant and the said application is under Order 6, Rule 17 of the Code of Civil Procedure, read with Section 151 of the said code. Full stop. The learned counsel submits that as regards to the amendment sought for under the said application, the petitioner does not have any objection, but the objection is as regard to the transposition of the plaintiff number two, namely
Santosh Shah.
Santosh, দাঁড়ান,
32 page.
plaintiff number 2, namely SANTOSH, Santosh SHAW, Santosh Shah, who has been allowed to be transposed as in the array of pro forma defendant. Full stop. He further submits that under Order 6, Rule 17, there is no provision for transposition. Instead, it ought to be under
Order 1, Rule 10.
Order 1, Rule 10,
Sub-Rule 2.
Sub-Rule 2, or Order 23.
Rule 1.
Rule 1, Order 1, Rule 10, Sub-Rule 2, or under Order 23, Rule 1A of the said code. Full stop. In support of his contention, the learned counsel has relied upon an authority published at 2024 SCC online. প্রথম দিন হচ্ছে 2020 volume 14 Supreme Court cases, page 1, and has also relied upon a judgment published at 2024 SCC online, Patna 8327. By referring to paragraphs 8 and 11 of the judgment of the Honorable Apex Court, the learned counsel has stressed that the law of procedure relating to the parties, to a civil suit is essentially contained in Order 1 of the Code of Civil Procedure, dealing with various aspects concerning joinder, non-joinder, and misjoinder of parties. And Rule 10 of the said order specifically provides for addition, deletion, and substitution of parties. Full stop. In respect of the judgment passed by a coordinate bench of the Patna High Court, the learned counsel has relied upon paragraph 7 and has submitted that the inherent powers are to be exercised by the court in very exceptional circumstances for which the code lays down no procedure. Banking upon the aforementioned authorities, the Learned Counsel has sought for allowing the present civil revision. Full stop. Paragraph. Per contra, the Learned Counsel, representing the respondents of opposite parties,
Opposite party number 1,
What?
the plaintiff only.
who has been
Aviator.
transposed.
Yes.
Representing the opposite party number 1, oblique plaintiff, submits that to the application under Order 6, Rule 17, apart from transposition from the array of plaintiff to the pro forma defendant, from the array of plaintiff to the pro forma defendant, the plaintiff has sought for further other amendments which have been specifically laid down in the said application in details. After what was the transaction? After
Lordship,
deed of-
after, during the pendency of the suit,
what has forced you, compelled you to file the Order 6, Rule 17?
yes, after, during pendency of the suit, there was a partition deed between the plaintiff number 1 and 2, and the plaintiff number 1 was allotted the suit property.
As because the suit property involved in the before the trial court fell in the portion of the sole plaintiff, plaintiff number 1. As such, the plaintiff number 2, and the plaintiff number 2 has obtained a separate portion which does not have the jurisdiction, territorial jurisdiction of this suit property. Full stop. As such, the original plaintiff number 2 has no right, title, or interest in respect of the suit property. Full stop. Which has compelled the plaintiff number 1 to file the application under Order 6, Rule 17. Full stop. Paragraph. The Learned Counsel has further submitted that through the said application under Order 6, Rule 17, amendment was sought for, and in addition to that, transposition of a party has been sought for, and has further of a party has also been sought for, and has further submitted that apart from Order 6, Rule 17, there is mention of Section 151 of the said code. Full stop. In support of her contention, paragraph, in support of her contention, the Learned Counsel has relied upon a judgment of the judgment of the division bench of this court, published in AIR 2009, Calcutta 160, and has relied upon paragraph 1(3) of the said judgment, wherein a judgment of a 5 judges bench of the Honorable Apex Court has been quoted. প্যারাগ্রাফ 13টা দিয়ে দেবেন, ঠিক আছে? And has stressed upon the point that the Honorable Apex Court, through the judgment published in AIR 1985 SC 1416, in the case between Union of India versus Tulsiram Patel, has laid down that Union of India versus Tulsiram Patel has laid down that if a source of power exists by reading together two provisions, comma, whether statutory or constitutional, comma, and the order refers to only one of them, comma, the validity of the order should be upheld by construing it as an order passed under both those provisions. Through the said judgment, it has further been laid down that even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. Full stop. Considering the submission of the learned counsels representing the petitioner and the opposite party,
Number 1, my lord.
opposite party number 1, it transpires that the crux of the issue is as to whether transposition of one of the plaintiffs to the array of pro forma defendant can be allowed under Order 6, Rule 17 under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure, wherein, apart from transposition, further other amendments were sought for. Which have been laid down in details in the said application. Full stop. It is fact that Order 1, Rule 10, Sub-Rule 2, or any other specific provision has not been mentioned in the said application, but in the said application it has been mentioned that the said application is being filed under Order 6, দুবার হচ্ছে under the said application, ঠিক আছে? That the application is being filed under Order 6, Rule 17, read with Section 151 of the said code. And in the said application, apart from transposition of one of the plaintiffs to the category of pro forma defendant, there are, ধরতে পারছেন তো, নালে যেন পরে গিয়ে ভুল না হয়, তখন কিন্তু গুলিয়ে যাবে। কি বলুন লাস্ট সেন্টেন্সটা। There are several other aspects which have been laid down in details in the said application under Order 6 Rule 17, which comes purely under the purview of amendment, that is Order 6 Rule 17. Rule 17. Full stop. In such circumstance, there is in such circumstance, there is no specific mention of Order 1, Rule 10, Sub Rule 2. But the amendment which is in details and the transposition have been allowed through the said application filed under Order 6, Rule 17, read with Section 151, which is not barred in this context. The judgment of the Honorable Apex Court supports, wherein it has been categorically mentioned that if a source of power এইখান থেকে, if a source of power exists by reading together two provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. তারপরে প্যারাগ্রাফ হচ্ছে 13 এর এই যে এইখানটা থেকে 13টা ঢুকবে আর এই যে এখান থেকে একদম এই যে মানে if a source থেকে further even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order whether source of such power exists. এইখানটা অবধি AIR 1966 Supreme Court 740 আর আরেকটা আছে এইখানটা AIR না AIR নয় 1983 Volume 2 SCC page 422 এইখান অবধি. As such, from the above discussion, it is clear that the trial court has not committed any error in allowing the application under Order 6, Rule 17, read with Section 151 of the Code of Civil Procedure, and in addition to the amendments, has transposed one of the plaintiffs, that is plaintiff number 2, to the category of pro forma defendant. In such situation, this court finds the order passed, impugned order to be correct and requires no interference. As such, the civil revision is dismissed, full stop, without any cost. Learned counsel, up to this one. At this stage, the learned counsel representing the petitioner, sorry, the opposite party, plaintiff number 1, seeks an order as regards to expeditious disposal of the title suit.
I am being led by my senior.
In my revision, she cannot ask for expeditious disposal.
But Lordship, she will not be prejudiced. No one can say.
But
whatever,
Not in my revision. Every time she does this.
Every time she does this. And what is the fate? Sometimes
it is allowed.
It is allowed.
I leave it to your
But
Lordship.
this time it won't be.
Then Lordship will not kindly record that, because that may go against me. If your Lordship is not given, well, then kindly don't.
I'm great.
Good.
Why were you not there?
Yes, he was
Today
sitting
also-
behind my lord and
No, no,
enjoying.
at that time, Lordship was dictating the order. That is why I did not come. Because a matter was going on in court number 17, Lordship. I attended.
On the last occasion also,
Yes, yes. That time,
no,
in that building
no,
and
uh, he had done he has played his part very well.
yes, Lordship, he had come prepared today. I'm great.
Sorry,
No,
next.
Item number 4.
I am appealing for the petition, Lordship. Petitioner applicant. There are 4 applications, Lordship.
I'm for the opposite party number 3 and 4.
4 applications.
4 applications. One is, first is, can number 1 is restoration application. Thereafter, Lordship, can 2 is a substitution. In connection with the substitution, Lordship, can 3 is a section 5 application. And last application is a order 22 rule 4. What happened, Lordship, during the pendency of this revisional application, the opposite party number 1 expired, Lordship.
Divisional application of 2019.
Hey,
Just of 2019.
19. Lordship. During the pendency, he expired.
Suit for eviction.
Suit, no, Lordship. Suit
Or
was
partition.
filed by the petitioner, plaintiff petitioner for consequential relief and for the permanent injunction.
No declaration.
No declaration.
Only
Declaration declaration for the consequential relief as well as the permanent injunction. The suit was pending before the court below. Lordship, what happened, Lordship? The recalling application, restoration application was filed within
Let me
the time.
find out the applications. Can 1 of 23.
23.
Can 2 of 23. Can 3 of 23. Where is can 4?
Can 4, that is the
এখানে 3টে আছে তো আরেকটা
Can 4 is a very important, Lordship, because order 22 rule 4 application is very much necessary, because, Lordship, the name of the opposite party should be setting aside, sorry.
one of the
opposite party number 1.
এখানে নেই নিন can 4 নিন can 4 is not in the record. It will have to be tagged with the record, and on a single day all the 4 applications
Yes.
will be disposed of, because partly it won't be taken.
No. Because one after this, that is related, Lordship.
Can 4 has been filed in 2025.
Look, Can 4 was filed, Lordship.
25,
Lordship. 30th April 25.
Item number 4. On perusal of the record, it transpires that the last application, that is Can 4 of 2025, it is not in বুঝেছেন? Can 4 of 2025 is not in the file. In such situation, the department is directed to trace the said application being Can 4 of 2025 and to tag with this file.
Affidavit service is to be
প্রথমে নিয়ে নেবেন affidavit of service. You are representing
3 and 4, my lord. Opposite party number 3 and 4.
Opposite party number 3 and 4. Who are 1 and 2? One is Omid Dan.
One is already died.
Oh, one has expired. Omid Dan. Order 22.
That
Rule
of
4. Order 22 rule 4.
Yes.
So Subroto Mondol is alive.
Yes. 2, 4, 2, 3, 4 are alive.
Let the matter appear. Let the matter appear on 17th of September, because 2 weeks this bench won't be available.
17th September.
17th of September, as this bench won't be available during ওই কত যেন 31st 31st August to 11th of September.
17th September.
17th September.
Last August, on lawsuit told me that if the Chatterjee is not, Chakraborty is not available, then I will have to plead this matter. Due to that is it, I am sitting since 10:30 to carry out the order of the lordship.
So, কি বলছেন? Order 1, Rule 10, Sub Rule 2. আর অর্ডার যখন দেবেন না সিপিসি তখন রোমান, ঠিক আছে? হ্যাঁ, না
Item number 66.
Your Lordship, I'm appearing for the CBI. Mr. Ganguly was addressing his argument. So today he's supposed to complete his argument. Thereafter, he may file a written notice of argument so that I may take time for addressing your Lordship on the next occasion. But anyway, I think he missed the bus. So I can inform him. Your Lordship will make a short passover. Yes, I can. Mr. Ganguly,
Yes.
বলো তুই কি বলবে Lordship?
Lordship, kindly give us a short password.
Very well.
So, Your Lordship, my senior, he's engaged elsewhere, so he'll be here very soon. Very short, whatever Your Lordship pleases.
Or when your Lordship.
No. As it is fixed today at 2 p.m., it will be taken up. Because the learned counsels.
No, I
who
have
are
no
appearing-
difficulty. I'm here.
the Learned counsels who are representing in the civil revision applications, they are apprehending that criminal appeal will continue. When to be taken up? How much time?
Lordship.
5 minutes? 10 minutes?
15 minutes, Your Lordship.
15 minutes. Very well.
2:15.
2:50. Very well. I'm waiting.
Much obliged.
Yes.
ওই কতদূর হলো আমাদের 4 অব্দি হয়েছে তাই তো
হ্যাঁ না হয়ে গেছে
4 হয়ে যাবে হ্যাঁ 5 নম্বরটা রাখুন তাহলে
Item number 5.
কখনোই জানে হচ্ছে 2 PM এ ক্রিমিনাল অ্যাপিল পাওয়া যাবে না হ্যাঁ যেহেতু ফিক্স করা আছে ওই জন্য কেউ হ্যাঁ পরেরটা রাখুন হ্যাঁ 1 minute লাগে বলছি যে সকালবেলা
For the petitioner, this is an application under section 24 of the CPC for transfer from Kharagpur to from Pingla.
matrimonial
Suit from
you are
Kagdip
for the
to-
wife
I'm for the wife.
allowed or dismissed section 24
Section
CPC
24 is before your lordship.
Achha.
Transfer from Kagdip to Kharagpur.
why didn't you prefer
He was granted by this court.
যখন শুনুন যখন কোনো yes,
Your Lordship, I obtained an order of stay from this court before service upon the opposite party. I served upon the opposite party appeared and submitted that there was a talk of mutual between the both the parties.
Hmm.
But that didn't went well, Your Lordship.
Learned Counsel, this is of 2019 civil revision.
Your Lordship.
You serve once again.
Upon the learned advocates who appeared.
Yes,
Yes, Your Honor. May I serve a notice upon the learned advocate?
learned advocate. But if the learned advocate says that he is not he or she is not appearing on behalf of the opposite party,
Thereafter, I will
then
serve upon the party.
immediately you serve on the opposite party so that the matter can be taken up
Yes.
on the next date.
Your Lordship, kindly grant me 2 weeks.
The opposite party is residing in South 24 Parganas,
South to meet at Kakdeep.
Kakdeep.
Yes.
How much time?
2 weeks, Your Lordship,
2 weeks.
because I will serve upon the learned advocate first.
The learned counsel representing the petitioner wife submits that the present application under section under Article 227 of the Constitution of India has been filed seeking transfer of the matrimonial suit being number 232 of 2018 pending before the learned additional district judge at Kakdeep, South 24 Parganas. At what stage it is now?
I have to ascertain.
Disposed of, I think.
No, it's not disposed of, Your Lordship. I have to ascertain, Your Lordship.
হলো সেন্টেন্সটা পড়ুন তো from the district of South 24 Parganas to the district of Paschim Mednipur, as because the wife, namely as because the wife oblique petitioner is residing in Paschim Mednipur with her two minor sons. As such, she is unable to contest the said suit. Full stop. He further submits that the prayer for transferring the suit from South 24 Parganas to West Midnapur is only for the purpose of contesting the suit, as she is a lady and is unable to travel such a long distance. Full stop. Paragraph. As this application is of the year 2019, as such, and as such about the and the opposite party husband has not appeared today, and after a long gap the said application has come up for hearing. In such circumstance, the learned counsel representing the petitioner is to serve notice intimating the next date upon the learned counsel representing the opposite party and also upon the opposite party. Let the matter appear on 14th of September.
Yes, your lordship.
14th. Let the matter appear on 14th of September. Under the head and to file an affidavit in this regard. Under the same heading. Next.
Item number 7.
Next.
Item number 8.
Next.
Item number 9.
না থাকলে বুঝলেন না থাকলে রেকর্ডটা রেখে দিন পরেরটা ডেকে দিন
Item number 10.
And in this matter, lordship, I am appearing for the applicant lordship preemptive petitioner. Now, lordship, the other side lordship was
section 8
WBL attack lordship. Now the issue is regarding the entire share with demarcated portion was transferred by the lordship vendor of the preemptive. Now lordship, your lordship knows that the issue is pending before the larger bench regarding entire share and demarcated portion whether preemption will lie or not. Now for this lordship, the application was several location directed to go out of list with the liberty to mention, but the same issue has not yet been decided by the larger bench. Lordship, currently comes the lordship order of admission.
One larger bench has taken up the matter as regards to whether the amount to be submitted
short deposit.
Short deposit.
Another was lordship regarding the lordship home Bastu. And lordship now the pendency lordship regarding the entire share which has not been answered by the lordship larger bench.
What was the last order before the previous bench?
Previous bench lordship on 9th of April 2019 it was admitted and lordship directed to serve lordship. Thereafter several occasion it was before Justice Mukherjee lordship it was go out of the list because the issue is pending before the larger bench, so the court could not lordship decide the matter.
My lord, I am for Mr. Pradeep Kumar Chatterjee, the opposite party. My lord.
Yeah, the preemptor.
Yes, prayed for not today. My lord asked me to appear.
Convey your submission.
আচ্ছা
Out of liberty to mention যেটা করা ছিল আগে সেটাই করে
এবার জিজ্ঞেস করে আসি
কালকে একদম
হ্যাঁ my lord kindly make it not today.
No. When can it be taken up? Has any date been fixed by the
lordship? 1 week before it was lordship the larger bench was seated lordship, but it was not decided. So when the next sitting
hearing is carrying on?
Yes, hearing is going on. So when lordship the next sitting will be we are not aware of the lordship. This is the difficulties. Your lordship can follow from the orders is several occasion it was adjourned on that issue. না আমি তো it was 19th ম্যাটার বলে এগুলো ওল্ড ম্যাটার বলে চলে এসেছে।
The learned counsel representing the petitioner submits that the self-same issue is pending before a larger bench of this honorable court, and until and unless the said issue is decided, this matter cannot be taken up. Um, that is CO 1306 or reference
1306.
one. Reference has been made in connection with CO 1306. Sentence last sentence. Decided. This revisional application cannot be taken up. Consider the submission of learned counsel. It reveals that reference in respect of CO 1306 of 2009 in the case between
19.
huh?
So reference lordship is not
2000, not 2009.
9.
Yes, 2009. আমি কি বলেছি 2019 বলেছি 2009. 2009 in the case between Mayarani Hajra and Narayan Chandra Rai is pending before larger bench of this honorable court. Full stop. In such circumstance, let this matter appear on কত তারিখ আজকে 22-24. Let this matter appear on 22nd of September.
It is better to appeal lordship after monthly list of October.
Let this matter appear in the monthly list of October.
As well.
My lord, let it be on 22nd September. If it is decided, the matter will be.
Hearing চলছে আগের দিন বসে উঠে গেছে শোনেনি কেউ hearing হয়
That's why it was
one of the judges also lordship is changed lordship because presently lordship Justice Banerjee Sabyasachi Bhattacharya and Saugata Bhattacharya is leading the bench. So instead of Kapur lordship, Saugata Bhattacharya has been lordship in the bench. So once again lordship the hearing has been started. Last occasion we came to know that no one appeared because earlier occasion lordship
let it appear in the monthly list of October.
As your lordship. Grateful, my lord.
Next.
Item number 11.
Next.
Item number 12. Item number 13.
For the petitioner, my lord. That the petitioner here in my lord died, my lord, long time back, my lord. The matter was out of list, my lord. That's why, my lord, we did not, my lord, was in contact. We were not in touch with, my lord, the client. After, my lord, the matter came, we established contact and came to know, my lord, died, my lord, long time back. Even though, my lord, I've already served, my lord.
Step has been taken.
My lord, I'll, my lord, take the steps, my lord. My lord, just, my lord, day before yesterday, it came to our knowledge, my lord. Already, my lord, the revisional application, my lord, has been abated, my lord. There needs to be an application, my lord, for setting aside of the abatement along with a continuation of delay, my lord. I'll, my lord, take all the necessary steps, my lord. Kindly grant me some time.
Affidavit of service.
Yes, yes, yes. My lord. Service of the revisional application, my lord. Service of the revisional application.
Whole petitioner has expired.
Kindly, my lord, keeps this on record. After I file, my lord, the application, my lord, again I have to serve, my lord, certainly. My lord, this was served long back, my lord. This was, my lord, this service is of. This is of, my lord, 2024. My lord, when, my lord, it was admitted. The revisional application.
At the time, the petitioner was alive.
Yes.
Then, what's the use of keeping that one?
Then, my lord, let this be with me, my lord.
The learned counsel representing the petitioner submits.
My lord, kindly keeps this since my lord already the revisional application has already been served. Now my lord, only my lord the copy of the application will be served upon my lord the opposite parties.
Um, an affidavit of service of
Didi.
dated, an affidavit of service dated, dated
Affirmed on 10th of July 2024.
10th of July 2024 has been filed. Let it be kept with the record. Full stop. At this stage, the learned counsel submits that the petitioner, sole petitioner, has expired and steps are required to be taken in this regard. Full stop. In such circumstance, let the matter appear on 21st of September.
21st, your lordship.
21st of September. Next.
একুশে জুলাই 26 ও ওইটা এটা 21শে জুলাই 2023 24 10th July 2024 ওটা হচ্ছে এভিডেন্স সার্ভিসটা আর ম্যাটার টু অ্যাপিয়ার অন 21st সেপ্টেম্বর
দেখুন তো ক্রিমিনাল অ্যাপিলটা এলো কিনা
ওয়েট
ক্রিমিনাল অ্যাপিলে হ্যাঁ আসেনি nobody has come on behalf of.
So your lordship kindly takes on the next week, my lord.
No. The matter will be taken up. Next week this bench won't be available.
Now, can it be day after tomorrow? Well, I mean, on 28th. 27, I have difficulty. My lord, that
Please be waited. दिन একবার দিন দেখি ওটা
Number 66.
পরে বললেন he is there. The other side, my lord,
learned counsel,
filling time was
you cannot submit standing there. From the beginning, your senior was not there. Somebody else was submitting. He had continued, I think, 2 or 3 days.
Yes, he's junior, chamber junior. I know him.
At least 2 days.
Yes.
And on the last occasion, your senior had come. He apprised the court that he will be able to submit from today. Now, it on consent of both the sides, it was fixed at 2 p.m. Learned counsel, if you are not interested, let the matter go out of the list. Because there are several litigants and the learned counsels are waiting for those matters to be taken up. Apprise the court whether it can be taken up today or not. Come with the information.
Would it be possible for your lordship to give us another Passover?
Passover, my lord. The lordship may fix a date, my lord.
Passover for
2:45.
I have also, my lord, matters before the other court, my lord.
let your
Very
deal
well,
be there
very well.
at 2:45.
2:40, very well.
Next.
Item number 14.
I am appearing for the petition.
Yes.
If the defendants have been served paper book has been made an appeal against an order passed in a suit for under section 6 of the specific relief. I was the defendant therein. The suit has been 14 matters.
14. Civil revision.
Yes.
Yes.
So the written notes have also been filed.
Without without having any submission, written notes have been filed.
No, because of the coordinate bench, it was heard, my lords. Certain orders were passed, coordinate bench had heard. So, but I will absolutely place it from the beginning before my lords, absolutely.
What about the opposite party?
They have appeared all along. Lordship wishes, we can give them a copy. Lordship fixes it on any day. I mean, copy as in I can intimate them with a notice if it so desires.
Learned councils were representing on
Yes,
behalf
ma'am.
of the party.
Yes, ma'am.
Lastly, on 17th of February also represented.
Yes, my lords. Yes, my lords. They have also filed a notes, is what I have been told. Well, it was at that stage, but we'll obviously trouble my lords with from the beginning.
No, it has to be heard. So, the petitioner is being represented. পিয়ন কোথায় গেল? ইসিও চলছে না নাকি? কোথায় গেল? পিয়ন কোথায় গেল? ডেকে দিন। The petitioner is being represented, but none is representing the opposite party. In such situation, the matter cannot be taken up. From the order sheets, it transpires that the opposite party was being represented. As such, the learned counsel representing the petitioner is to intimate the learned counsel representing the opposite party as regards to the next date. Let the matter appear on 22nd of September.
My lords, whenever. Grateful.
এদিকে আসুন। Next.
Item number 16.
I appear for the petitioner pursuant to your lordship's direction. I have served the other side.
Lord, I am for the
And is appearing.
ডিরেকশন বলতে কবে ডিরেকশন ছিল?
না আগের অর্ডারে আপনাকে সার্ভ করার।
ও আচ্ছা।
Yes, my learned friend is I filed my affidavit of service.
এটা number 16, তাই তো? Yes, learned counsel.
My lord, kindly fix a date so that my lord.
No, it will be taken up today itself.
On the point of issues, certain judgment has been delivered by Justice Shironmoy Bhattacharya. So, my lord, that should be taken into consideration.
Everything will be taken
For
into
that,
consideration.
yes, for that, my lord, time is required for consideration of this
Who
judgment.
will submit first? You or he will submit first?
Next one is the
So,
petition. He is the petitioner.
Let him start.
Yes.
Well, this application is a revisional application, assays the order by which a application for amendment filed by my learned friend client was allowed.
Where is the impugned order?
Impugned order is at page
Dated 14th of November 2019.
Kindly give me a minute. I'll just the lordship of page.
No, I have got it. Order number 43.
Yes.
Order number 43,
Page,
dated
yes.
14th of November 2019.
Yes.
Page 18, page 18.
Page 18 is the order.
Learned Counsel, what is the title suit?
Title suit is for recovery of bills of the West Bengal State Electricity Board.
Achha.
Kindly come to the plaint.
Plaint is that page.
Before that, my lord, let me first place the impugned order. Your lordship will get the entire matter from there. At page 37.
I'm going through the certified copy.
Yes.
You're placing the first page.
Yes.
Internal first page.
This is, yes, 14/11/2019.
Yes, yes.
This day is fixed for, may I place the order?
Yes.
It will make everything clear. This day is fixed for passing order on amendment application filed by the plaintiff on 30/9/2019. Both sides take steps by filing haziras, peruse the application, written objection and the materials on record, heard both sides. On the last occasion, the facts giving rise to the application under Order 6, Rule 17 of the CPC may be traced out first in the following manner. It has been stated that while filing the suit, the plaintiff committed some errors in the figure of valuation as well as at some of the other features of the plaint who are sought to be amended as per schedule of amendment. Since some records were misplaced at the relevant time and such errors need to be rectified by way of amendment. As for the relevant notification in force, the distribution part of the plaintiff company has been transferred to West Bengal State Electricity Distribution Company Limited, WBSE DCL, on and from 1/1/2019, and such change need to be incorporated in the plaint by way of amendment. Learned advocate for the plaintiff has argued to allow the amendment application in terms of the schedule of amendment. This was opposed by the defendant by filing written objection. The learned advocate for the defendant has categorically submitted that save and accept the change of nomenclature of the plaintiff company as per the relevant notification in force. Other portions of the schedule of amendment as sought for are liable to be rejected, since these issues were well within the knowledge of the plaintiff at the time of institution of the suit, and the same cannot be incorporated at this mature stage of the suit without any lawful excuse. Defendant has relied on decisions reported in AIR 2009-1433 in support of his contention to the effect that the amendment of pleadings cannot be permitted at this stage, save and except the change of nomenclature of the plaintiff. This is after the amendment of Civil Procedure Code. I will place this judgment. Having regard to the rival contentions made by the learned advocate appearing for the parties and materials on record, it appears that the decision relied by defendant is on different facts and circumstances and is not applicable in the instant suit. It is the settled principle of law that the purpose of amendment is necessary for the purpose of determining the real question in controversy between the parties. Prayer for amendment for change of nomenclature due to the above referred reasons seem to be formal in nature, but the amendments sought for in respect of the other issues are necessary for the purpose of adjudication of this suit, particularly at this stage when recording of evidence has not commenced. Considering the pros and cons of the matter, nature of dispute between the parties and principles of law to govern permission under Orders 6 Rule 17, this court is of the considered view that the proposed amendment will not change the course of the suit, but the plaintiff petitioner save and accept the change of nomenclature ought to have come up with the amendment application being filed. WS counterclaim in respect of the other issues as per schedule of amendment, and such approach of the plaintiff petitioner demonstrates lack of, kindly mark the words, the approach of the plaintiff petitioner by this amendment at this later stage of the plaintiff petitioner demonstrates lack of due diligence. This is noted by the learned judge. This is a finding. Lack of due diligence while instituting the suit. So while instituting the suit, he should have but did not bring to the notice of the amendment, the additional claim. I'll come to it. As such, the amendment application deserves to be allowed with costs. Hence, the application under Order 6, Rule 17 of CPC Code, read with 151 of CPC is allowed on contest, subject to payment of cost of ₹1500 to be paid by the plaintiff petitioner to the District Legal Services Authority (DLSA) Paschim Bardhaman before the next day. Upon compliance of making payment of such cost, plaintiff petitioner is given liberty of the file the amended plaint before the next date after service to the defendant in the meantime.
Yes.
So this application is allowed. Now I'll show. Now I have 3 points. May I
You
just
are prejudiced
by this amendment? First, kindly see the amendment application. What amendment is seeking for?
Let us first go to the plaint, Learned Counsel.
Very well, very well. Let us go to the plaint. Just give me a minute. I shall. Page 41.
40.
Yes, 40. I'm obliged, my lord. My lord, plaint kindly come to paragraph 6. This was the claim.
Paragraph 6.
Yes. Claim bills raised by West Bengal State Electricity Board. This was the claim. Now kindly see that as per bills submitted by the plaintiff company, that is the case of my learned friend, the defendant never paid in respect of either by check or cash in favor of the plaintiff company up till now. The total amount is lying due of rupees 7,25,88,000. This even 25,81,000, of which outstanding balance amount is 3,18,85,36, etc. 136 as on 31/3/2019, and against bill number so much, dated at a total of which is 7,25,88,202. So this was my learned friend's claim, 7 crore. This was the final claim in respect of bills. Now by
total claim is 7,25,000.
7 crores, 7 crores,
25,88,000.
Now, yes.
Yes.
If your lordship comes to the prayer also at page 43, it's the same figure. Page 43 is the prayer.
7 crore 28,88,000. Yes.
Yes. Now, my lord, will kindly come to the amendment. What is the amendment sought for? Kindly, the amendment application is at page 47.
Yes. We'll come to the schedule.
Schedule of amendment. Kindly come to the learned judge while passing the interim order. I relied on this passage. Schedule, page 48.
Yes.
Kindly see.
No, page 40. It starts from page 47.
47. The relevant portion is at page 48.
Achha. Learned counsels.
My lord. Oh, sorry.
My lord, subparagraph E.
Yes, E.
At page 3 of paragraph 6, the figure
So,
7 crore 20.
Wanted to enhance from 7 crore.
Yes.
From 7 crores to 9 crores.
Yes, but my first question is this addition. No particulars are given. Number one, but the first point is why he couldn't make the enhance. Why my learned friend client could not make this claim at the time of filing the suit. He has to give, because this amendment is brought for after the issues are settled, the hearing has commenced. So after amendment of CPC, Order 6, Rule 17, after amendment says, amendment after the hearing has commenced.
1 minute, 1 minute. It was filed in during the year 2014.
Yes, after kindly come to the order sheet. Kindly come to the order sheets.
1 minute.
Issues were framed. I'll just take your lordship.
You have annexed the entire order sheet?
Yes, entire order sheet.
It commences from page number?
It commences from page number 20. The relevant order, I'll just indicate, my lord. Just give me a second.
filed on 22nd of September 2014.
Yes. Now kindly come to page 27. Kindly come to page 27.
Page 27.
Yes.
Yes.
Second order, 5/3/2018.
Order number 23.
Today, yes, today is fixed for framing of issues.
Issues have been framed.
Issues have been framed. So Supreme Court, 1999 Supreme Court, I'll just place the judgment, says that the hearing commences when the issues are framed. And if that be so, after amendment of CPC, no application for amendment should be allowed after hearing commences unless sufficient cause is shown. I shall presently cite the Supreme Court judgment. My first point is that here in this amendment application, nothing has been
at a belated stage. First point.
Belated stage means specifically after the hearing has commenced. That is the section. After hearing has commenced.
Issues framed on 5/3/2018.
From the date of commencement of
5/3/2018. Yes.
I am not saying that amendment cannot be filed. I am saying unless sufficient cause is shown. My point is, nothing has been shown by my learned friend as to why he was precluded from filing this additional claim on the date when the suit was filed. Nothing is stated. The second is, if your lordship again comes back.
When the Order 6 Rule 17 application has been filed?
Order 6 Rule 17 application was filed on (47). (24th April 2019), page 50.
24th. Plaintiff files an application under Order 6 Rule 17.
I'll come to the judgments. I'll just indicate my points.
1 minute, Learned Counsel. Order 6 Rule 1 minute. Order 6 Rule 17. Order 6 Rule 17 on 24th April 2019. Yes.
So my first point is that no explanation has been given why my learned friend could not raise this additional claim at the time of filing the suit and waited till the hearing commenced, and he is hit by Order 6 Rule, amended Order 6 Rule 17, which says that if after amendment application is filed after hearing commences, then it can only be allowed if sufficient reason is shown. I am saying no reason is shown. Before coming to the merits, my second legal point is, in any case,
yes,
there's nothing written that this claim arose later. This claim
So according to you, at the time of filing of the money suit, this
should
claim
have
was-
been raised.
this claim was prevalent.
My second point is, the suit, your lordship will see, was filed in the year suit number 34, 2014. Now he is trying to introduce this claim, additional claim and claim on account of delayed payment surcharge. That's another claim in 2018 by amendment. By amendment, Supreme Court has stated that you can cannot include a claim which is barred by limitation on the date of amendment. He should have made this claim in 2014 when the suit was filed. He cannot be allowed to, by way of amendment.
The next point is it is barred by limitation.
Incorporate a claim which is barred by limitation.
So according to you, when this arose, when the cause of action
2014,
arose,
the same day, because nothing has been shown that this additional claim arose later. He says that he has discovered later that there's additional claim. No sufficient cause given, number one.
Instead of preferring within 3 years, they have filed it.
Tried to file it in 2018.
2019.
2019.
After 5 years.
Right.
Next point.
The next point is on merit. Number one is that I have just shown, learned judge himself has said that plaintiff has not shown due diligence.
Not shown due diligence.
If not known,
in spite of that, how could be?
In spite of that, how
could have been allowed? How
could be allowed? Number one.
Next point.
The next point is no particulars. Your lordship will kindly see.
No details has been given.
No details that was my learned judge recorded in the interim order. No details of this, how this additional nine additional amount which raises the claim from 7 crore to 9 crore, and no additional documents regarding delayed payment of such as nothing.
Additional claim. Achha. Now we are
and another aspect.
1 minute, from 7 lakhs 25,000 to 9 lakhs 8,000.
9 crore 8 lakhs.
9 crore
8 lakhs. 9 crore 8 lakhs.
Near about 1 crore 75 lakhs.
Yes.
80 lakhs enhancement.
Yes.
Out of 1 crore 80 lakhs enhancement, what amount is the additional claim and how much is the interest, or what you are saying that?
No, I'm saying this additional, no explanation. This 7 crore was the original claim.
Was the original
Now
claim.
he has increased it by, suddenly in 2019 has increased by 1 crore, more than 1 crore.
1 crore.
There's no particulars, no documents, no.
Under which heading? Additional claim. The entire is of additional claim, or in addition to the additional claim, something has been.
What he has
also
indicated,
added.
kindly come to page 48 once.
Yes, 48.
At page 3 of paragraph 6. 7 crore 25 lakh 88,000 appearing number 4 should be deleted, and in place 9 crore 8 lakhs.
Oh, so the
same claim is being enhanced.
The claim is being enhanced from 7 crore 25 lakhs to 9 crore 8 lakhs.
This is one aspect. The other aspect is a totally new claim. The other aspect is a totally new claim for which there is no pleading.
Which one? Which one?
The next plus
That,
9 crore 8 lakhs
plus
delay payment surcharge. There's no particulars, nothing. Yes.
In the plaint, whether
nothing. No,
there
this
was
case
mention
not.
of whether there was any whisper of
No whisper.
delay payment surcharge?
No, nothing. Kindly have a look at the plaint.
1 minute. 1 minute.
So
what were the prayers in the plaint for the money suit?
Prayers in the plaint.
Decree we passed for recovery of money, so 7 crore.
Yes, that's 7
lakhs. Apart from that, 80,000 only against the defendant company, cost of the suit, further accrued bank interest. Oh. So there is no whisper of that
delayed
payment surcharge, delay
nothing,
payment
nothing.
surcharge. Anything more?
Now, may I want to in
Rely upon
support
yes,
some
authorities.
decisions. Yes, may.
How many?
3 or 4. I'll just
No,
find.
2.
No,
On this issue,
the different there are different points. I just want. Just give me a
the point is whether at this stage it can be filed or not, in spite of knowledge having at the time of filing of the money suit.
I'll start with the decision which cited before the trial court, which is very clear, Justice S.B. Sinha's judgment.
Reference টা বলুন।
2009 SC 1433.
এগুলো কিন্তু এনভেলপে ঢুকিয়ে দেবেন, ঢুকিয়ে রেখে দেবেন, ঠিক আছে? আর যখন আমাকে পাঠাবেন তখন আজকে সকালবেলা যেগুলো সেগুলো দিয়েছেন তো? মানে ওগুলো এনভেলপে ঢুকিয়ে রেখে দেবেন। Yes.
My lord, kindly come to paragraph.
You are referring to AIR 2009 Supreme Court 1433.
Yes, kindly come to paragraph 11. Referring to an earlier judgment, then quoting from earlier judgment 2004-1 SCC, kindly come to the last paragraph. Last paragraph of the cited quoted judgment, which is approved, which is upheld. At this point, the para 11, part of para 11. At this point, the question arises: when does the trial of an election petition commences, or what is the meaning of as to assign the word trial in the context of an election petition? In a civil suit, the trial begins when the issues are framed, and the case is set down for recording of evidence. All the proceedings before that stage are treated as proceeding preliminary to the trial or making the case ready for trial. I am relying on this, my lord. Now then, kindly come to paragraph, subparagraph 42 of the other judgment which is quoted, 2005-6 SCC. On the same page, kindly come to 42, it is noted that provisions of Order 6, Rule 17 CPC have been substantially amended by CPC Amendment Act 2002. Now I'm on this. Under the proviso, no application for amendment shall be allowed after the trial has commenced.
After the trial has commenced.
Unless in spite of due diligence, the matter could not be raised before the commencement of the trial.
Yes.
So it is submitted that after the trial of the case has commenced, no application of pleading shall be allowed unless the above requirement is satisfied. The amended Order 6, Rule 17 was due to the recommendation of the Law Commission, since Order 17 as it existed prior to the amendment was invoked by parties interested in delaying the trial. That to shorten the litigation and speed up disposal of suits, amendment was made by the Amending Act 1999, deleting Rule 17 from the code. This evoked much controversy, hesitation all over the country, and also leading to boycott of courts, and therefore the Civil Procedure Code Amendment Act 2002 provision has been restored by recognizing the power of court to grant amendment. However, with certain limitations, which is contained in the new proviso added to the rule. The details furnished below will go to show as to how the facts of the present case show that the matter which are sought to be treated, sought to be raised by way of amendment by the application well within their knowledge on the court case, and manifest the absence of due diligence on the part of the appellants deciding them to the relief. So my submissions is twofold. One is that it was within their knowledge. Nothing has been stated as to why they were precluded from raising the claim at the time of filing the suit. And my second submission, the learned judge himself, the learned judge in the lower court has himself raised questions about the diligence, said that it was the plaintiff, there was a lack of due diligence on part of the plaintiff. So because of these twofold reasons, the amendment could not have been allowed, because the issues I have shown your lordship, the issues were framed and the amendment has been, application has been admittedly filed.
Next.
The issues. The next case is Just give me a minute.
Well, next.
Yes, the next case is again on due diligence, another case. Specifically, the Supreme Court says that if there is no due diligence, amendment cannot be allowed. This is 2020-11 Supreme Court cases 549, a recent decision. 2011 SCC 549, paragraph 8. Head note and paragraph 8.
Page 49. Right, sir?
Let me.
Any other?
Another decision, my lord, 2008-14. This is on the aspect of limitation, the point which I wrote. This was may I?
If it is barred by if it is barred by law of limitation,
Cannot be included
it
by
cannot
your
be
amendment.
included.
Just I'll give that with para 11. Yes, 2008.
Yeah.
No, Supreme Court cases 2008. 2008 14 SCC 632.
Paragraph.
I'll just place that. Paragraph 14. May I place my
yes.
From the above, therefore, one of the cardinal principles of law in allowing or rejecting an application or amendment of GD is that the court generally, as a rule, decline to allow amendments if a fresh suit on the amended claim would be barred by limitation on the date of filing of the application. So, on the date of filing the application, 2019, that additional, that increased claim, if it was not made earlier, is barred by limitation.
So if it is barred by limitation, then
that additional claim cannot be that amendment on that
Order
ground.
Rule 17 cannot be
Yes.
allowed. But that would be a factor to be taken into account in the exercise of the discretion as to whether the amendment should be ordered and does not affect the power of the court to order it. If that is
in the
required,
interest of justice,
if
but
that
I have
is
said
required in the interest of
in this
justice.
case the interest of justice would, because my first point clearly says there were not there was no due diligence. So in the interest of justice would not call for this order.
That's all.
And
why and? That's all. That's all.
Very well, my lord. Those are my submissions.
Because you don't have any other point.
Yes.
You have relied upon Limitation Act. You have.
My lord, I must came back to your lordship by considering this judgment, but my learned friend cited.
Do you intend to come tomorrow?
No, my lord, I'm coming.
Do you intend to come to?
My lord, give me at
Be
least
prepared.
2-3 days.
No, not 2-3
because
days, not as.
my lord, kindly.
As regards to this proposition, not
My lord,
2-3
this
days.
proposition, your lordships kindly consider. Just 2 minutes, give me. This is an LPSC. The amendment filed for delayed payment of surcharge. LPSC calculation made
What is the full form of LPS?
late payment surcharge. Well, suppose.
Late payment surcharge.
Yes.
In the plaint, where have you mentioned?
My lord, that has not been, my lord, kindly consider. At the time of filing plaint, my lord, why LPSC, why this amendment of plaint was?
That will be considered if there is any instance in the plaint wherein it is mentioned.
My lord, then, my lord, if my lord the plaint is covered, then the question of filing amendment does not arise. Why this was happened? Your lordships kindly consider.
You are saying LPS.
Late payment surcharge, because
1 minute. Late payment surcharge. You are banking upon that.
no, not banking, my lord. The facts, my learned friend says
In the prayer portion.
due diligence.
In the prayer portion of the plaint, you have mentioned a decree be passed for recovery of money of rupees 7 crores 25 lakhs.
Yes.
88,000.
Yes.
In the pleadings, wherein you have mentioned as regards to delayed payment surcharge.
My lord, that was not there. Only current bills figures have been mentioned. Now, my lord, your lordships kindly consider the 2 aspects. We are the distribution company. We are raising bill to a company. There was a stipulated period for making payment. If the company paid within the stipulated period, question of my lord LPSC does not arise. Now, if not paid, then my lord, after completion or over the stipulated period, my lord, the delayed payment surcharge was accrued. Now, my lord, at the time of filing plaint, the current consumption bill was mentioned. Now, LPSC come later on. If I am not paid my electricity bill, line will be disconnected. Then, my lord, after completion of the stipulated period, late payment surcharge will go on accrued.
Now, as
Now,
regards as regards to 7 crores 25,000.
That is for?
That is for?
That is for regular bill.
No. The court is seeking as regards to the tenure. From which date to which date? This amount accrued.
Well, that was
accrued.
Your lordships kindly come to page 50.
Page 50.
50.
Yes.
Kindly see. May 12.
Consumption month is May 2012.
12. Amount.
Thereafter.
Amount.
1 minute. Thereafter June 2012.
Yes, my lord.
Thereafter July
Yes.
2012. 2012. Yes. 2012.
12. Now amount. Amount was mentioned.
7 crores 26
Well,
lakhs.
whatever amount is mentioned.
So this
Bill
is
date.
This is of July, May, June, and July 2012.
No, my lord, I am coming. Your lordships kindly see the calculation. My learned friend has not shown this. So, my lord, bill dated mention 12, 12, 12, 12, 12, 14. Bill date was mentioned. Now, my lord, due date was mentioned.
Learned counsel, when from which date, after expiry of which period, the late payment surcharge comes into effect?
Immediately after the stipulated period over.
Let us take into consideration that for the month of July 2026, one could not pay during the month of August 2026. Then from September,
LPSC.
September 2026,
yes,
late payment surcharge will accrue. So,
but that calculation will not be shown in the bill, next bill.
Let it be.
No, your lordship, that is the important thing. That should be taken into consideration. That is the important factor. The next bill,
1 minute, Learned.
my lord.
So, the company has not paid for the month of May, June and July 2012.
And 14th also. Bill dated, my lord, 30th.
In page 50, where have you mentioned?
30th May 2014.
Where is that?
And the bill dated last. The bill dated column last.
Bill dated 30th May 2014. Except that one, the earlier one, the first one is of 7th of June 2012. Second one is of 6th of July 2012.
Yes.
Third is 16th of August 2012. And the fourth one is of 16th of
January.
That is short payment.
Yes.
Short payment.
Short payment.
So let us take into consideration August, the last one. So from September, late payment surcharge accrues September 2012. So one has to pay within August 13, 14, 15. August 2015, late payment surcharge, and that's the last date. Within October 2015.
That is the bill date.
No, Learned Counsel, late payment surcharge.
No.
Because he has not.
My lord, perhaps I am not clear to your lordship.
I have understood, Learned Counsel. If I am unable to understand, then you will say.
Yes.
30th August 2012, he could not pay 15,95,477. That is the bill for consumption for July 2012.
15 lakhs. Yes. July.
15,95,477.
Yes.
So, bill date is 16th of August 2012. He could not pay that. So,
due date is 30th August 2012.
30th August 2012.
So last
from
30th.
1st September, the late payment surcharge accrues start.
Yes.
Cause of action is 1st September 2012. 3 years, 2013, 2014, 2015.
That's the
September 2015.
Yes, your lordship.
Completes.
Well, that should be taken into, that is the problem.
And you have filed the application under Order 6, Rule 17 on 24th of May 2019.
No, that is prior to, after filing this suit. LPSC, my lord.
Whatever is the query of the court has placed before you.
Well, I am ready to give answer to the queries of the court.
Yes.
First of all, my lord, your lordships kindly consider what is the concept of LPSC. Immediately after, so long the regular bill will not paid, we are not in a position to calculate the LPSC. Lordships kindly consider, until my learned friends clients paid the regular bill, we are not in a position to calculate the LPSC. That is the most important thing should have to consider by your lordships, because in my electricity bill,
in the Order 6, Rule 17 application, where have you mentioned that one?
No, Order 6 rule that was mentioned by mistake.
No. Everything is by mistake, and everything cannot be taken into consideration.
No.
By mistake. Where have you mentioned in Order 6, Rule 17?
My lord, whatever your lordships, my lord, will pass an order that will abide by us. I am not on that.
That is not the
what
question.
Is not there is not there, my lord. I am not, my lord,
that is the question from the.
I am not, my lord, in a position to approve the lacuna what is there in there.
Where have you mentioned in the application under Order 6, Rule 17?
No, Order 6, Rule 17 mentioned, my lord, that some error of total additional calculation crept into the drafting of the plan because of few documents were not then available, which had been misplaced. Such error are very much important in the decision of the suit, and therefore the plaintiff intended to incorporate the said error in the plan by way of amendment, which is very much required for the proper adjudication of the suit. Well, I will come to a judgment that Supreme Court says yes, if it is required for proper adjudication of the judgment, the amendment should be allowed even at the later stage. even after completion of evidence also, that I will come to your lordships. Now, my lord, your lordships kindly consider the, so far my largest friend is saying diligence, due diligence, my lord, there is no scope. Because unless my largest friend paid the amount, the question of calculation of LPSC does not arise. Because I do not know when he will pay it. So long the consumption, my lord, is still, the LPSC will accrue. Even till date also LPSC will be accrued. And but by limitation, second thing is my understanding is I will come to the judgment, my lord, but so far my answer to the my lord, the question of limitation but does not arise. That is the
limitation
does not arise. That was cleared by the judgment of this court also. The moment the relationship between my learned clients and myself was cut up due to disconnection, I have no obligation to raise any bill time to time to my learned company. And Justice Sanjeev Banerjee, as his lordship then was, my lord, in electricity matter, there is a judgment. My lord, today, my lord, all of a sudden matter came to before your lordships. But I must clear that there is no question of but by limitation does not arise so far the my lord payment is concerned.
Lord Counsel, the matter has not come up all of a sudden.
No, today.
Lastly, on 10th of August, it was there. On that day, nobody had
Yes, that was not my knowledge. That I later on I have seen, my lord. I am not blaming anything, my lord. I am just.
Whom to be blamed?
Yes, my lord, it's my fault. That's why, my lord, I am saying this is my fault. The matter was listed.
Now you are
Now
to
3 points my learned friends
you have to provide two citations.
Yes.
One is
limitation point.
limitation point
Another is amendment
for the ends of justice.
Yes.
Yes. When can you provide?
Give me 3 days time at least.
Let the matter appear in on Wednesday. Thursday. Thursday.
My lord, one aspect I missed since I'm just I'm sorry to interrupt. One point. This a delayed payment surcharge. I missed that point. Is a new claim brought in by amendment which changed the nature of the suit, which I did not raise. That is another point I'm raising. It's a totally new claim, not there in the plain.
No, not new.
Which cannot be brought in by way of amendment.
No, this is
Lord
not
Counsel,
new.
the point which
I'll
he has
not-
added is
Yes.
LPS changes introduction of LPS changes the nature and character of the suit.
Yes, new claim. I
No,
forgive him.
how this can be, my lord, change the nature and character of the suit? The main, your lordships kindly consider, LPSC arises from the main.
Learned Counsel,
Yes.
it is his contention.
Yes, contention. Yes.
You will have to controvert.
Yes, how it can be, my lord, to change the nature and character? Then, my lord, kindly take it next week, my
Take
lord.
the defendant by surprise. Takes the defendant by
Thursday.
surprise.
No, my lord, kindly take it next week because certain questions raised by learned friends, I shall have to sit with my clients also because they are the Asansol. And Wednesday is this, my lord, holiday. So,
And this bench won't be available for the next 2 weeks. That's why it is.
no, Monday, Tuesday, any day.
Monday, Tuesday, Wednesday, Thursday, Friday, Saturday. Thereafter, Monday, Tuesday, Wednesday to Friday. This bench won't be available for the next
week,
2 weeks.
Next week, your lordship.
Circuit bench. That's why it is being kept on Thursday.
My lord, after coming from circuit bench,
No,
your
no,
lordships
no.
can fix the
No,
matter.
no.
No, your lordships kindly consider, my lord, I shall.
No, Learned Counsel.
Then as your lordships.
Let the matter appear. Heard the Learned Counsel representing the petitioner in full stop. Paragraph. The Learned Counsel representing the opposite party.
Well, kindly make it Friday.
Friday is a holiday.
Thursday.
Friday holiday, no, Friday holiday.
Thursday, Learned Counsel. Let the Learned Counsel representing the opposite party commences his submission but could not conclude and submits that several authorities are required to be furnished. Full stop. As paragraph as the Learned Counsel intends to file certain authorities, let the matter appear on Thursday.
Well, citation judgment including arguments also because I am not
Yes.
concluded.
Everything you have not concluded. It is
Yes.
mentioned there.
Yes. So, my lord, 3 points: nature and character,
Yes. nature and character,
limitations,
limitation.
and amendment can be done even after completion of evidence.
Yes, these 3 points.
Yes. That Supreme Court judgment I will bring, your lords. That Supreme Court says amendment can be done after completion of evidence also.
এটা পাঠিয়ে দেবেন আজকে, ঠিক আছে?
এগুলো ফেলে রেখে যাচ্ছে, এগুলো নেই।
ওই
স্যার, এখানে আরেকটা রয়ে যাচ্ছে, আপনি
ক্রিমিনাল অ্যাপিলটা রাখুন।
তো ফেলে যাচ্ছেন। দুটো কোম্পানি তো সলভেন্ট কোম্পানি। চলো, গ্রেটফুল টু এই
ওই ক্রিমিনাল অ্যাপিলটা রাখুন, ক্রিমিনাল অ্যাপিল।
Item number 66.
Yes, Your Lordship, I am appearing for the opposite party, CBI.
Learned counsel, first of all, are you eager to dispose of?
Millard,
Eager.
Millard, I apologize, Millard. What had
Nothing to apologize, but eagerness is to be shown.
Millard, Millard,
Let
we
us-
are
let us-
eager. Millard, the only difficulty is, Millard, I'll tell the practical difficulty that happens is, Millard, the major benches, criminal benches, Millard, are in that building, either the new building or the Seski Centenary building.
What can be done? It has been.
I understand. Millard, that is the logical difficulty. So the eagerness is not the difficulty, it's the logistical difficulty coming from there, and Millard, it just creates a bit of a difficulty. Millard, I'll be candid, Millard. I'll complete placing everything today, Millard. Only, Millard, next day, Millard, Thursday, Millard, we'll keep you on Thursday. Mr. Ganguly will conclude with judgment.
Thursday.
This Thursday we'll conclude.
This Thursday I have difficulty. I have
1 minute. Why not tomorrow?
Millard, tomorrow, Millard, there is some fixed matter, Millard, is there, Mr. Ganguly.
Let your junior be there.
My lord, this Thursday, my lord, 7 matters are fixed, my lord. That is the difficulty. So
I'll complete placing everything, Millard, because
let
Let
you
us
complete.
start.
yes, Millard, let us start, Millard. I'll go.
এটা নয়, ওই এভিডেন্স অর্ডার বুক দিয়ে লাভ নেই, এভিডেন্স। পেপার বুক তো আছে, পেপার বুক আছে।
Millard, just to give a small recapitulation, what is there, Millard? What had happened in this case, Millard, you should I'll recollect, Millard. There was a trap that was laid down inside the office of the appellant, who was the then tax assistant, Shuri Income Tax Office, Ward number 3, Rampurhat, wherein the de facto complaint had made an allegation that to pass the income tax return of the de facto complaint, PW1, a bribe has been demanded by the appellant for
Rupees 500.
of 700, which had subsequently been agreed at 500. Then Millard, pursuant thereto being aggrieved, he goes to the CBI. He informs CBI the entire facts of the matter. CBI conducts a post-trap evidence, makes everything ready. Thereafter, they come along with shadow witnesses to my office. While I am present in my office, along with other officers, the PW1 comes inside my office. When he comes inside my office, Millard, I admittedly refuse to accept the sum that was bribe of rupees 500 rupees note. I refuse to accept it. Subsequently, another person, Sushanto Sengupta, who is termed to be
according to the complaint, he is the agent.
He's my agent.
Who
Millard.
used to collect?
That is their version, Millard.
According to the complainant.
Millard. It was he had come in, he had handed over the money to Sushanto Sengupta. Upon handing over the money, CBI barges into my office, completes the raid. Now, Miller, thereafter the trial goes on. The trial was conducted under Section 7 of the Prevention of Corruption Act and Section 13(2), read with Section 13(1)(d) of the Prevention of Corruption Act 1988. Now, Miller, after the trial, Miller, during the period of trial, Miller, 13 witnesses were examined by the prosecution. Miller, after completion of the trial, the co-accused, who was also put to trial, that is Sushanto Sengupta, he was acquitted by the learned trial court. I was acquitted under Section 120B, criminal conspiracy.
The person who had received the amount. He has been acquitted.
He has been acquitted. I have been acquitted of Section 120B of the Indian Penal Code, which is criminal conspiracy, and I have been convicted under Section 7, read with Section 13(2) and 13(1)(d) of the Prevention of Corruption Act.
You have been directly implicated and convicted.
Yes, I've been directly implicated for accepting bribe, and I was convicted. Now, Miller, during the pendency of this appeal, the appellant, Miller, he succumbed to cancer, Miller. His son has been abated in the case. Now the records have been changed. Now,
Incorporated.
His son wishes to get the appeal hearing done. One, to make sure that his posthumous father's name is cleared, and two, Miller, there are certain, since he was a public servant, there are certain retirement, there are certain benefits which the family can get if he's acquitted. Miller, these were the circumstances under which the appeal was being heard. Now, Miller, first, Miller, I'll just give a short recap what had happened. Miller, I'll not place everything. I'll start from PW10. I'll just recap what had happened. Now, Miller, first PW1. PW1 was Mr. Pulok Mondal. Miller, he was the de facto complainant. Miller, the important part is de facto complaint was declared hostile by the prosecution because he did not corroborate the fact of a proper demand of money by the accused, by the appellant during the evidence that was given by him. He did not say that the appellant before your lordship had demanded any money for completion of his income tax return. So pursuant thereto, Miller, he was declared hostile, and after that, Miller, he was cross-examined by the prosecution, and thereafter he was cross-examined by us, Miller. Miller, thereafter, Miller, PW2, Miller, he was the it's page 9 at the very last, Miller, is where I laid emphasis. I wanted to pay rupees 500 from my pocket, but the accused refused to receive the same. At that time, accused Sushanto Sengupta entered the office and I paid him rupees 500 to the accused Sushanto Sengupta on demand, who put the money in his pocket. So, Miller, according to the version of the PW1, Miller, why am I raising the emphasis is because, Miller, Section 7 of the Prevention of Corruption Act lays down two facets, Miller. One is demand, one is acceptance. So, Miller, the Supreme Court, Miller, I'll place those judgments also. Mr. Ganguly will elaborate on that. The two facets which are there for completion of an offense under Section 7 of the Prevention of Corruption Act are demand of illegal gratification and subsequent acceptance. If both have to be proved, until and unless both are not proved, the offense cannot be said to have been committed. So, Miller, the version of the de facto complaint PW1 was that the appellant did not demand any bribe from him, illegal gratification. It was Sushanto Sengupta, whom he had handed over, who has subsequently been acquitted by the learned trial court on the basis that there is no evidence against him.
You have been convicted under Section 7, Section 13, subsection 2.
Read with 13(1)(d).
13, subsection 1, clause D.
Yes, Miller. And for section yes, Miller. For Section 7, I have been convicted to suffer an simple imprisonment for 6 years, and for Section 13, read with 13(1)(d) for 4 years, Miller. And both sentences have to run concurrently. Ought to have run. Now, Miller, the sentence part will not be of much importance. It's only
one thing I like to point. Just know what my lord submitted by my learned friend at the time of substitution of the legal heir who is conducting the appeal. Well, there is no indication about the reasons of conduct. That I will, when I will start my argument, I will place that. My
As
lord,
regards
what he
to-
is saying
as
now
regards to-
that for, my lord, goodwill,
To-
apart from goodwill, certain monetary benefits or eternal benefits which has
External
ought to be
benefits.
paid if the person is not punished. My lord, that, my lord, point was not in the application.
This is only short thing. This is my statutory right under section
No, I'm
390.
denying statutory right.
These are to him consequential reliefs.
If at all I get, I am, they are of no importance to this case. If I'm convicted, then
If his father is cleared,
if he's cleared, then those happen. Otherwise, I will place my case only to the facts of this case. I have just indicated, if at all if your lordship is inclined to overturn my conviction, these are the benefits that I might give. That is all.
the court is not concerned.
Exactly.
court
The
is
court
not
cannot be
concerned with
concerned. Yes, the court cannot be concerned
That
with
will
that.
have to be brought in another
forum. That is another forum. I've just indicated that to your lordship. That is of no consideration for the list of this case. Thereafter, PW2, I'll not lay much emphasis. PW2 was the sanctioning authority, who had, there's a requirement under section 19 of the Prevention of Corruption Act that any public officer who's to be prosecuted under the act, it's at page.
You have stressed upon second line of the second paragraph, page number 15. I
15.
cannot recollect as to whether accused Badri Alam was transferred prior to the date of occurrence.
Yes.
I cannot tell as to whether the accused Badri Alam joined under the office of ITO 1 prior to the date of occurrence. I have not enclosed the documents produced by me prior to according sanction.
Why I place this is because section 19 says that any sanctioning authority, while granting sanction, has to apply its mind to the facts of the case and only thereafter can grant sanction. So these answers that have been provided by the sanctioning authority,
Mind was not applied.
shows that he had not even applied his mind. That on the day of the incident, the appellant was under an order of transfer. He was to demit his office. PW3 at page 16. He was one of the seizure witnesses, who had accompanied
Yes, PW3.
At PW3, Karthik Mondal, he was one of the witnesses who had accompanied the PW1 inside the office of the appellant when the alleged incident happened.
This witness has stated that the accused answered that he did not perform any work by taking any money.
Yes.
Thereafter, the accused Badri Alam called one Sushanto Sengupta. Accordingly, Sushanto Sengupta came to the accused. The accused instructed the complainant to pay the amount of rupees 500 to the said Sushanto Sengupta. Accordingly, Sushanto Sengupta received the money
17
from the complainant. Page number 17, page number 18.
Yes,
From the complainant amounting rupees 500 and inserted the said money in his left side shirt pocket. 1 minute. Accordingly, Sushanto Sengupta received the money from the complainant amounting rupees 500 and inserted the said money in his left side shirt pocket.
Sushanto Sengupta took the money, kept it like this in his pocket.
Whose shirt was dipped in the chemical?
Sushanto Sengupta.
Sushanto's shirt was
Yes,
dipped.
mine was not because it was admitted.
Which turned red?
Which turned red. Sushanto's hands were dipped in the chemical, which turned red. Sushanto's shirt was dipped into the phenolphthalein powder, which had turned pink, when exposed to the chemical. Milord, only thing, Milord, I would also like to add, Milord, which had probably missed on the previous occasion, Milord, is that Milord will see also page 17, Milord, second paragraph. Milord, there is an important, Milord, in the second paragraph, we'll see 1, 2, 3. Milord, the fifth line, CBI had also inserted one mobile phone in the pocket of the complainant. The CBI. CBI also instructed the complainant to switch on the mobile phone before entering the office of the accused. Now, Millard, why I was laying emphasis on this, and Millard, which I had previously not placed properly before your lordship, was, Millard, well, when I'll be placing the final judgment of the learned trial court, Millard, the learned trial court has accepted all these facts. What has swayed the learned trial court to pass a conviction in my favor was that there was a voice recorder which was placed inside the pocket of the PW1. PW1, when he entered into the office of the appellant, Millard, that voice recorder was purportedly on. There, the conversation was recorded between what had happened, Millard, apart from the individual witnesses who were present there. There were the entire conversation was recorded therein. Upon recording of those conversations and hearing those conversations at the time of passing of the judgment, the learned trial court found it fit to convict the accused person on the basis of these conversations recorded in the voice recorder. Now, Millard, first things first is PW1, while he has given his entire deposition, Millard, while he was being cross-examined by the prosecution also, he does not mention of any voice recorder being kept in his pocket. There was no voice, there was no whisper of any voice recorder being kept into the pocket of the PW1, which has formed the basis of conviction of the petitioner.
Contradiction.
Contradiction, he has not stated anything. The contradictions will come subsequently, Millard.
One has stated, one has not stated.
But the one who has not stated is the one from whom the person on whom the voice recorder was purportedly placed.
Yes.
And now, Millard, PW3, Millard, he's the witness, Millard. Why I place this line, Millard? He also does not mention of a voice recorder. He mentions of a mobile phone being placed inside the pocket of PW1. So, Millard, here for the first time, the prosecution states that a mobile phone was placed inside the pocket of the PW1, that is the complainant. So till now, there is no whisper of any voice recorder. The first witness who was present inside the place of occurrence says that there was a mobile phone purportedly in the pocket of the PW1 complainant.
Yes.
So Millard, I will recollect page 20, Millard. I have highlighted the portion, Millard, in the first paragraph.
But I have knowledge that the said Sushanto is not a government employee.
Yes, Millard. Millard, first of all, Millard, I would like to say the prosecution has not been able to establish who was Sushanto Sengupta, because every witness has said different things about Sushanto Sengupta. And now Sushanto Sengupta has been acquitted, and his acquittal has not been challenged by CBI. Millard will keep these in mind while reading the deposition. The role of Sushanto has not been properly established by the prosecution. And prosecution, because of the lapse on the part of that prosecution, Sushanto has been acquitted by the learned trial court, which is not being challenged, which has not been challenged by the CBI, and now that has attained finality.
Yes.
Because, Millard, what has happened, there are some places they are saying that Sushanto was a person who used to work, who used to be inside the ITO office, used to do the computer works. And then, Millard, subsequently, there are suggestions that are being made, Millard, that Sushanto was no one, Millard. He was, in fact, an agent who had helped PW1 to file his returns before the income tax authority. Like, Millard, there are several agents that go around, like when we need passports, Millard, there are agents whose help we take, who help us through the process. Millard, that has been established. Sushanto, someone like that, who had helped the PW1 to complete his ITR properly fill up his income tax return and submit it before the concerned authority. Because that is why it says, I did not make any inquiry as to whether Sushanto is an authorized person to submit IT return or refund or an outsider. So, this is the portion where nobody is clear what has happened. Thereafter, I have placed the last paragraph. Bhadre Alam did not receive the he has again admitted PW3, because these are the only two eyewitnesses, PW1 and PW3. PW3 has again admitted that Bhadre Alam did not receive any money from the complainant. He did not demand any money from the complainant. He stated that he did not work on receipt of money. He repeatedly stated to us that he had shifted himself from the department and he had no connection with the department. So, this is what the independent witness has also corroborated, that the appellant before your lordship continuously refused to accept any amount from the PW1 complainant and had in fact intimated them at the very inception that he is under an order of transfer. He cannot help them in any which way. Now, this is what has come from PW2 or PW3, which we will be laying emphasis on. Now, PW3 PW4 he's the he's the CFSL expert regarding all the chemicals that were there. I am not placing them much before your lordship. I'll go to PW5. He is the second witness. PW5, page 24. He was the second witness who was also present. There were two independent witnesses, PW3 and PW5. PW3 entered with PW1 inside the office. PW5 did not enter into the office, but he purportedly accompanied both the other witnesses to the place of occurrence. He was outside the place where the incident occurred. That is, he was outside my office. He never entered my office. Now, PW5 for the first time states that a voice recorder, that is at 1, 2, 3, the third paragraph, page 24, fourth line, a voice recorder was placed inside the shirt of Pulak Mondal, PW1.
This is the first time the word voice recorder comes
in, my lord. Now, he thereafter, since he was yes, thereafter, PW5 does not further shed any light on the facts of the case. He only admits and he exhibits all the other documents which he was a party to, like the notes that were there, the impugned notes.
From the third last line of the third paragraph of PW5.
Yes, Miller.
The said rupees 500 currency notes of 100 rupees each was recovered from the shirt pocket of one Mr. Sushanto Sengupta, who used to work under the said accused, Mr. Bhadre Alam.
So, he now says that he used to work with me. So, there is again discrepancy of the role of Sushanto Sengupta, which was also the fact of reason why he was acquitted. The prosecution has in no way clarified who Sushanto Sengupta was, despite the fact that he is the person who has purportedly accepted the illegal gratification.
Yes.
Thereafter, at page 25, the very last line. Although he admits that there was a voice recorder placed inside the pocket of the PW1, he says that he had heard the conversations,
but
he cannot recollect
contents of the same.
So, he has no recollection of the conversations that was purportedly recorded inside that voice recording. So, the witnesses per se have in no way shown to the court that what was the conversation that was being recorded in the purported voice recorder. Now, my lord, why this gains importance is because, my lord, one, there is a voice recorder. The placing of the voice recorder inside the pocket is itself doubted because of several contradictions. Subsequently, my lord, the PW1 never mentions about any.
Very few of them has said about recording of voice.
Yes, ma'am.
Some has said about a mobile phone. Some has said voice recorder.
Voice recorder, and the one who had said about voice recorder, he says that he does not remember the conversation that was recorded in the voice recorder. So there is no proof of the conversation. Why, Miller, this is gaining importance is because, Miller, I was again going through the judgment. The learned trial court has been only swayed by the conversation that he has heard himself from the voice recorder, Miller, and he is completely given a transcription in the judgment, which had swayed him to pass a judgment against me.
Well, the word has been used as contents, not conversation, if I am correct.
Contents
Contents of the voice recorder.
I'll again read, Miller. The line is, the voice recording of the conversation between Pulok Mondol and Bhadre Alam was later heard by me, but I cannot recollect the contents of the same. So, Miller, I failed to understand, Miller, it is what I had submitted, that he had heard the conversation. He failed to recollect the contents of the conversation that he has heard. Millard, I'll also be raising this another point, Millard, while I'll be placing my judgment is, Millard, there's a judgment of the Honorable Supreme Court that when a voice recording is done of an accused, the first that voice recording has, Millard, I'll come to that. Millard, in fact, let me come to that. I'll go to it then, Millard. I'll just go at PW8 only. Millard, this is the only portion of PW5 that was there. Now, Millard, PW6. Millard, he was the person who handed over the attendance register to the CBI. Millard, he is a person of the income tax authorities. Millard, he works at void number 4 at Shuri. Millard, he had handed over the the attendance register of that day to the CBI. Millard, and in the cross, he had also admitted that on 13th of June 2023, the accused was transferred to ITO ward number 2, and the two wards are separate, Millard. And now, Millard, there is another line that is also gaining importance is, Millard, PW page number 30, that the colleague of the appellant has stated that he has never heard of any allegations of any wrong allegations or accusations against the appellant before, Millard. So he has no previous conduct of any illegal actions being done by him as a public servant.
Tax isolation. You are referring to probably what is tax isolation?
Tax isolation in any case?
That is a different.
I have never heard any
No, I have never heard any accusation or allegation against Bhadre Alam accused. The page 30, third line, 1, 2, 3, fourth line, in fact.
Any accusation or allegation?
So this shows the conduct of the appellant, Millard, that was there in the eyes of the witnesses / his colleagues. Now, Millard, PW7, Millard, he was also an officer of the income tax authority. He had handed over the service book of the appellant to the CBI. Millard, of the services that was done by the accused person, Millard. And Millard, he also goes on to explain how the refund process is actually done in the income tax authorities, that all refunds are processed through through an online mode, and it is directly done from CPC Bangalore in a chronological manner, and the income tax officers have no role to play in the passing or in the fast processing of the income tax return of any taxpayer. because he says no one is empowered to tamper or violate with the serial number of the docket with respect to the receiving of ITR.
Yes.
This is important because that is the case of PW1, that he was purportedly paying illegal gratification to the appellant so that his income tax, his TDS is refunded to him earlier and his income tax is processed ahead of the queue. Now, my lord, the PW7 was also asked to hear the voice recordings that were there in the voice recorder, my lord. So, my lord, PW7, my lord, who is the immediate superior of the appellant, my lord, will see page 33. My lord, he has also admitted that when he has heard the voice of the person in the purported recorder, my lord, he cannot recollect or he cannot tell if the voice which he heard was that of the appellant. My lord, this person now comes and says, I cannot recollect if this is the voice of the
I cannot say whether the tap recorded
voice which I heard through an earphone was the accuser's voice or his mimicry.
Mimicry voice.
Now, my lord, PW8 is where my lord will also gain certain importance here, my lord, because he was the CFSL officer who had purportedly conducted the voice sampling between the voice of the the appellant and the voices that were present inside the tape recorder. Now, my lord, this is a this evidence, my lord, first, my lord, my humble submission here would be, my lord, his entire evidence has to be discarded by this honorable court only on the sole ground that, my lord, there is a three judges bench judgment of the Supreme Court which says that, my lord, whenever a person's voice recording has to be done, my lord, a sample of his voice recording has to be done, the prosecution or the CBI has to obtain a permission. Ritesh Sinha, yes, Ritesh Sinha, three judges bench judgment, they have to obtain permission from the court. Upon obtaining permission from the court,
that has not been done in this case.
That has not been done. So, today the voice recording which is being matched purportedly with that from the voice recorder, but it cannot be looked into because the voices, the sample voice which is purportedly said to belong to that of the appellant, my lord, that has been done without the permission of the magistrate, and therefore, my lord, the sample is an inadmissible piece of evidence and cannot be used into evidence to corroborate, if at all, any voices that are there in the alleged tape recorder.
Yes, Lord.
Millard will see page 35, paragraph 1, 2, 3, 4. Fifth paragraph, Millard. the auditory examination of the questioned voice marked as Q1 bracket BA and the specimen voice of the accused Sri Bhadrayalam marked as S1 bracket BA reveal that they are similar in respect of their linguistic and phonetic feature. This voice sample, which is exhibit S1BA, is not an admissible piece of evidence because this has been collected without the permission of the magistrate. There is nothing that has been revealed in the entire judgment which shows that there was any permission sought by the magistrate before recording the voice sample of the appellant. When was this voice recording recorded? Nothing is there. There's only a voice sample that has been sent to PW8 for his expert opinion.
Yes.
Millard, my respectful submission, Millard, which will be further elaborated by Mr. Ganguly, would be that the entire voice sampling has to be discarded and the entire portion of evidences which relate to the conversation, the voice recording, Millard, have to be discarded and cannot be looked into while passing any order. Millard, ought not to have been looked into by the learned trial court while passing its order. Whereas the learned trial court has heavily relied upon the conversation which she had heard herself from the voice recorder.
Yes.
Millard,
Next point.
now, Millard, I am coming to PW9. Millard, PW9, Millard, that is only for PW8. Millard, nothing more would be required for our part on PW8. Now, Millard, on PW9, Millard, we'll see that he's another income tax inspector who has gone ahead and has explained of the process of income tax. And Millard, he has also stated that CBI interrogated me. I was asked about the letters of Assessee Pulak Mondal and the letter from my department. One recorded voice clip was also placed before me. It contained conversation between two men. One voice was of accused Bhadrayalam. One transcript of the said conversation being part of the post-trap dated Itna was shown to me and I perused the same. Witness is shown the memo and he identifies. So Millard, he had actually signed the post-trap witness as the post-trap memo.
Yes.
Millard, thereafter, Millard, he has been cross-examined. The only two things which I would like to show to your lordship will be page 42, Millard, in his cross-examination.
I found no adverse remark or allegation against the accused during his tenure of service.
Yes. So this also further goes on to show the conduct of the appellant while he was under service. There was never any adverse remark. There was never any accusation against the appellant before your lordship.
And the other point.
And Millard, the other thing is, Millard, we'll see just the paragraph above. It is not, Millard, the second paragraph, third line, it is not possible to identify the voice of all the persons, only the voice with whom I am acquainted with. I can recognize. I did not give any certificate in writing with respect to recognition of the voice of the accused by me to CBI at the CBI office.
Yes.
Now, my lord, PW10, my lord, is my lord, PW9 is the portion till where I had stopped, my lord. I'll just quickly take your lordships through PW10, 11, 12, 13, my lord. They're very, otherwise not much, my lord. I'll just take few minutes of your lordship time, my lord. PW10 is the inspector of CBI. He was a post-trap and a pre-trap witness, my lord. He says that I'll just place it. I am working as an inspector, so and so, so and so. I was working at the same post and same place. I'm a member of the trap team. I witnessed all the trap witnesses, the pre-trap and post-trap incident on 12/6/2023. I was directed verbally by by my SP to visit Shuri Birbhum in connection with a secret operation. Accordingly, on 13/6/2013, I reached Shuri at UCO Bank at around 12 noon. Thereafter, Shri Sumit Das Gupta, that is PW12, I'll take your lordships through his evidence. Roshan Singh, not examined. Inspector Shuvendu Ganguly, not examined. SI Divanshu Khamboj, not examined. And SI Rajesh Kumar, not examined, along with the complainant, Pulak Mondal, and two independent witnesses, KC Mondal, which is PW3, and Amit Hasda, PW5, came to the UCO Bank Zonal Office Shuri, and we were all introduced there formally. So, my lord, out of all the people examined or named by the PW10, my lord, only 3 have been examined. Well, 4 if you count PW1, my lord, 4 have been examined by the prosecution. My lord, then, my lord, the complaint was regarding refund of excess.
How many charge-sheeted witnesses were there? Has the
That-
charge sheet been?
Charge sheet, my lord, that will be a part of the trial court record, my lord. It will not be a part of the paper book, my lord. That will be here, my lord. I'll have a look at it and my lord, I'll intimate to your lordship, my lord. Charge sheet, my lord, I'm also not.
Charge sheet,
But it'll be in the trial court records, my lord. এই দুটোতেই হবে। দুটোতে হবে। May I just have a check and then এটা তো order sheets আছে। It is I have it, this is the chart sheet. This is the this is the chart sheet, and at the very last page, of the chart sheet, we'll just turn a few leaves over. There is a list of witnesses, 17 witnesses, including
out of 16. 17 is any other witness.
But these names are there, we'll see.
Out of 16, 13 have deposed.
Yes, but these people have not been examined, Inspector Roshan Singh, Shubhendu Ganguly, Divyanshu Khamboj, and Rajesh Kumar. These are the names that are there. I just had a glance.
Roshan Singh, D. Khamboj,
Yes.
Rajesh Kumar, and
Shubhendu Ganguly.
Shubhendu, in respect of Shubhendu Ganguly's statement not recorded. In the case of Sri S. Bishwas, Inspector of Police, statement not recorded. Oh. So in respect of all of these persons,
yes,
including Roshan Singh, D. Kamboj, Rajesh Kumar, statement was not recorded.
Nor have they been examined, my lord.
Out of these 5, S. Ganguly to Rajesh, 10.
Yes, my lord. None of them are.
5 to 10, none have been
No, my lord, none of them. My lord, only Roshan Singh is here before your lordship, my lord.
Roshan Singh is here.
Yes, my lord. Only
Apart
Roshan.
apart from Roshan Singh,
My lord, nobody. My lord.
nobody.
Nobody, my lord, is here before your lordship.
Who were in the raiding party?
Raiding party. My lord, there is Snehangshu Biswas and Roshan Singh, and my lord, these two are the raiding team persons who are being examined.
Snehangshu Biswas has deposed.
Yes, my lord. Snehangshu Biswas
6
and
and 7. CSW 6 and CSW 7.
yes, my lord, and Roshan Singh. They have been examined. The others, my lord, who have been named, my lord, have not been examined by the prosecution.
No. Acha, okay.
My lord, and I am reading, my lord, PW10 Snehangshu Biswas. My lord, this is his statement. My lord, the complaint was regarding refund of excess TDS deposited deducted by the complainant's office during assessment year 2012-13 amounting to rupees 13,186 from the salary of the complainant and demand of rupees 700 initial demand and rupees 500 negotiated bribe amount subsequently demanded by the accused in consideration thereof to refund the excess TDS deducted by the complainant. Well, this is what, according to him, were the allegations. For refund of excess TDS deducted to the complainant. The demand of rupees 500 was last asked by the accused from the complainant and to pay the same latest by the next day on 13/6/2013. Now, my lord, this factum of demand, which has been the story that is being loomed that there was a demand that was done also previously.
Yes.
That there was a demand previously made by the Apple and Millard. That story, Millard, has not been corroborated anywhere, and there is no evidence leading to that effect. In fact, PW1 has also not stated anything about that. Now, Millard, okay, just place the relevant 45. Now, Millard, there are other factors. Millard, now he for the first time says that Millard will see at the second last paragraph of page 44. Millard, a new Philips Cogear voice recorder was unwrapped, opened, and was charged electrically at UCO Bank office, Shuri. Another independent witness, Amit Hasda, was asked to accompany the other team members to be present with them for the trap proceedings against the accused. One copy of the pre-trap was handed over to Amit Hasda, the independent witness. Yes, Millard. Now, Millard, at 1:45 on that day, or that is on 13th of June 2013, we all left from the office of ITO Ward number 3, Shuri, and reached there at around 2 p.m. Now, Millard, this is the next line, Millard, at page 45, assumes importance, Millard.
On being asked by TLO.
No, Millard, the line above that, page 45.
Yes, page 45.
First line, voice recorder was switched on and put into the chest pocket of the wearing shirt of the complainant. Now, he says that they had left, and thereafter, after they reached that place, the voice recorder was placed inside the pocket of the complainant. Now, this will also be contradicted by the next witness in the next evidence which I'll place, Millard. So, according to PW10, Millard, the voice recorder was placed inside the pocket of PW1 at the time they reached the ITO ward Shuri. Millard, Rajesh Kumar SI stayed at UCO Bank and with the remaining phenolphthalein powder. After 10 minutes, Mr. KC Mondol gave the prefix signal to us. I saw his signal. All of us then rushed there. So Millard and switched off the voice recorder, kept with the complainant. So Millard, this person is also a witness who had not witnessed the entire incident. He was also standing outside. Since he is a CBI officer, he did not enter the office of the appellant. Now, Amit Hasda then took the bribe money of rupees 500 from his right hand of the bribe money of sorry.
First, second, third, fourth paragraph.
Fourth paragraph.
On being asked by TLO.
Complainant. The complainant told that he gave the bribe money of rupees 500 to Sushanto Sen Gupta while pointing towards him and as per direction of Bhadrayala. So, he has said that, which is again a contradiction. This is not the version of PW1. That I placed the version of PW1, he has not stated anything like this in his evidence. The line that while pointing towards him as per the direction of Bhadri Alam is not what has been stated by PW1 in his evidence. So this is, I would say, a development that has been trying to be made by the CBI authority in his evidence. But the fact remains that the money was recovered from Sushant Sen Gupta. Thereafter, Amit Hasda, the para thereafter, Amit Hansda then took the bribe money of rupees 500 from the right hand of the accused Sushanto Sengupta. So, this is also another discrepancy that comes, the earlier, the witnesses have said that Sushanto Sengupta, who was PW3, he said that Sushanto Sengupta took the money and kept in his pocket. He says that when he went there, he saw that the money was being recovered from the hands of Sushanto. Notes were tallied and they were exactly the same with the SL number mentioned in the pre-trap memo. Thereafter, the procedure is there, that hands were washed, everything was done by them. Now, page 46, the first paragraph is somewhat of importance because, it says that the transcript of the voice recorded in the said recorder was taken in a laptop and was printed out. And its printout was taken. I signed the transcript and it formed part of the post-trap memo. Now, this transcript, is not an exhibit. But this does not gain much importance. The transcribe is because I am initially doubting the entire process of voice recording and the sample that has been there. So, even though this transcribe is not a part of any evidence, the conversation which does cause a bit of suspicion, but the fact remains that since it is
you are hitting in at the base of the
base, I am hitting it at the very base. So if that goes away, nothing else remains. If the base falls, the entire structure falls.
Branches only remain.
Thereafter, there's nothing much that is important, Again, only the first line of the cross-examination is relevant, Why I say this is because it says as I was not interrogated by the investigating officer of the case. None of my statements under 161 was recorded. I deposed on the basis of my memory. So this is his statement for the very first time before the court. So any contradictions that have been stated by him is because this is a statement for the first time made before the court, and the court ought to have looked at the deposition of PW10 with a certain, I would say, a certain caution, because this is his statement from memory. His words cannot be taken as gospel. And thereafter, he says that in the next page that he has not witnessed. The second paragraph, it is a fact that I was not a witness to the alleged demand and acceptance of bribe money by the accused. I cannot say what conversation took place between the accused and the complainant. I only saw Sushanto Sengupta entering the office of the ITO. I did not see Bhadri Alam entering the room. He was already present inside. Then the next paragraph, he then says that the bribe money was recovered from the shirt of Sushanto Sengupta after the complainant identified him, gave us an indication pointing towards Sushanto Sengupta. So that he himself contradicts his version. Once he says it's from the hand, one it says from the pocket, in cross and in the examination.
I cannot recollect whether any statement of the complainant was taken or recorded at that place.
Millet, your lordship.
Yes, page 47.
Is referring to.
Page 47,
Yes,
first
first
line. At that place, that is UCO Bank.
That is the pre-trap.
Yes, UCO Bank. At the UCO Bank, they gathered together and
They
made the preparations.
they
Prior to coming to the income tax office.
yes. So his statements that were informed to him, nothing was
My lord,
according.
in trap case, my lord, always, my lord, there is a procedure of pre-trap and post-trap, my lord. So unless there is a pre-trap, post-trap, yes.
Unless there is preparation,
Yes.
the
My lord.
matter cannot be fulfilled.
Millet, when PW 11 Millet from page 48 Millet, this is Inspector Roshan Singh Millet, who was another person present at the place of occurrence as a witness. Millet, he is a member of the trap team. Millet, I am just placing Millet. He has shed light only on the Millet. What I feel is now Millet, once he comes in, he now tries to shed light on all the contradictions on the portion of the voice recorder. Now Millet, we'll see from page 49. Now Millet, he does not speak much about the entire process of the pre-trap evidence that took place. What he does lay a lot of emphasis on the voice recorder.
Is to patch up.
Yes, my lord. That is to patch up. Miller, we'll see the TLO opened the new voice recorder from the packet and charged it electrically. The complainant produced 5 GC notes of rupees 100 each from so and so. Their serial notes were noted down in the pre-trap memo, and demonstration and reaction of the phenolphthalein powder and sodium carbonate was placed and explained to all of us by Rajesh Kumar. The said GC notes were treated. Miller, then Miller, I'll just come to the 4th paragraph, Miller. Now, Milord, he says that the voice recorder was kept in the shirt or pocket of the complainant and was instructed to switch on at the time of entering into the office of Bhadrayalam. Now, Milord, we'll see, Milord, while he's describing the entire process of pre-trap procedure carried on, he says that at that moment, the voice recorder was placed inside the pocket of PW1, wherein the other witness says that that voice recorder was placed after they reached the post-trap, the office of the ITO at Shuri.
The charged voice recorder was kept in the shirt pocket of the complainant and was instructed
to switch it on at the time of entering.
To be switched on at the time of entering.
Yes. So I am saying, Millard, because it is he is saying at the time when it was being kept in the pocket, in the pre-trap. Whereas PW10, another witness of CBI says it was done after the pre-trap was complete and they reached the office of
the
ITO. Millard, that is at page 45. Millard, your lordship will seize that.
Page 45.
Yes,
first
Millard.
line. Voice recorder was switched on.
Yes.
And put in the chest pocket of the wearing shirt of the complainant.
Millard, we'll see the line in the previous page. He has said that they had already reached the office of ITO. That's the line prior to that.
Around 1:45 p.m. on that day, we all left for the office of ITO and reached there at around 2 p.m.
Yes.
Voice recorder was switched on and put in the chest pocket of the wearing of the complainant.
So, in the 2 CBI witnesses who have been examined, they have themselves contradicted at the place where the voice recorder was placed, was placed inside the pocket of the complainant. That is PW1, who has never spoken of a voice recorder being placed in his pocket.
Yes.
Thereafter, I'll just place the TLO instructed the complainant to converse and communicate with the accused Bhadri Alam loudly in an audible voice. KC Mondol was instructed to act as a shadow witness and be in close proximity with the complainant and to keep an eye on the transaction and conversation between the complainant and the accused. We all washed our hands with soap and water. We carried our mobile phones and ID cards. Pre-trap memo was prepared and facsimile of brass seal was taken on the paper, which was signed by all of us. Signature of the witness was thereon are identified and marked so and so exhibits. Pre-trap concluded at 13:45 hours, and we left from the office of the ITO. We left for the office of the accused at ITO, Ward number 3, Shuri, Birbhum, at around 13:50 hours, and we reached that place within 10 minutes. The complainant and the shadow witness entered the room of the accused at 2 p.m. and Shushanto Sengupta entered the Shushanto Mondol, he has named, Shushanto Mondol entered the office of the accused Bhadri Alam at 2:08 p.m. At 2:10 p.m., shadow witness gave a prefix signal by scratching his head with both his hands, and the TLO passed that signal to us. Thereafter, we all rushed inside the office of the accused. TLO switched off the voice recorder. The complainant told us that on instruction of accused Bhadri Alam, he had handed over the tainted money to Shushanto, co-accused. This line again gains importance because this is a development by the CBI in their case, wherein PW1 has never stated that on the instruction of Bhadri Alam, the money was handed over to Shushanto. Thereafter, the witness conducts all the seizure and the exhibits of the post-trap evidence that takes place. May not be of much importance, but your lordship wanted to see was the second last paragraph, left pocket of the wearing shirt of Sushanto was also signed by me. So this was the shirt of Sushanto that was being seized and being used, the place from where the tainted money was recovered. So the prosecution has established that the money was not there at any point of time in the hands of Bhadri Alam, but was at all point with Sushanto, who has been acquitted. And his acquittal has not been challenged.
Yes.
Millard, will just seize page 52, the very last paragraph.
No, the complainant has said that it is fact that I paid the money of rupees 500 to the accused Shushanto Sengupta as per instruction of the accused Bhadri Alam.
This is the version of PW11.
No, PW1 also. PW1, page 11, second paragraph. Page 11, second paragraph. Fourth last line. It is a fact that I paid the money of rupees 500 to the accused Shushanto Sengupta as per instruction of the accused Bhadri Alam.
Will also see page 9, but he had also stated the very last line with the it's opened my page 9, the very last 4 lines. I wanted to pay the money of rupees 500 from my pocket, but the accused refused to receive the same. At the time, accused Sushanto Sengupta entered the office and I paid the money of rupees 500 to the accused Sushanto Sengupta on demand.
This is the contradiction.
This is his chief. So this is his statement. Now subsequently what your lordship had placed is the portion
cross-examination
by the prosecution once he is declared hostile.
Yes.
Now, Millard, otherwise, Millard, PW 11, there is nothing further that is to be shown because Millard, they were again not cross-examined at length. Millard, apart from that, I just wanted to show page 52, the second paragraph, the third line. Millard, like I've been placing, who was Sushanto has not been established by the
No
prosecution.
appointment letter.
Yes, my lord. No appointment letter of Sushanto, co-accused, was found during his personal search and office search on 13/6/13. I do not know about the job or profession of Sushanto. So who is Sushanto is completely unestablished by the prosecution in its case. Now, my lord, page 53 will be the PW 12. My lord, he is the TLO, my lord, the OC of Bhawanipur police at that time, my lord. PW 12 for it. The examination. Sorry. Of CBI. Yes, my lord. I stand corrected, my lord. He was an trap laying officer. My lord, page 53. I'll just place from the third paragraph. The complaint regarding the demand of illegal gratification rupees 700 later negotiated to rupees 500 by the accused Bhadre Alam from the complainant Pulak Mandal LIC agent Shuri for his licensed tax refund of rupees 13,000 so and after interest amounting to rupees 14,000, 5% approx cut money commission was demanded thereon, that is the amount of rupees 700 by the accused Bhadre Alam on 12/6/13 in his office at ITO. Millard, this portion is not corroborated anywhere. This version has not come up that 12th the demand was made by him in his office. There is nothing. The prosecution's case only starts after the PW1 has informed them about the.
This is the first time it has come up in the evidence of PW 12.
12 also, my lord. There was demand on 12 at the office.
Earlier there was demand of 13.
Complaint. Yes. Well, the
5% was demanded thereon.
Well, this is his allegation in the complaint, but there is no proof to that effect that there was any incident of 12th of June 2013 that has actually occurred. The prosecution has only relied after the complaint is filed and they've gone on from there.
Even the complainant has not said so.
He's not said so. But that forms a part of his complaint, his written complaint. Then on 13th of June 2013, trap team comprising of myself, Inspector Roshan Singh, Inspector S. Ganguly, Inspector S. Biswas, SI Divyanshu Khamboj and SI Rajesh Kumar assembled at UCO Bank, Shuri, under the instruction of SP CBI. Two independent witnesses and the complaint also came there. Independent witnesses were KC Mondol, BSNL officer Amit Hansda, UCO Bank employee. We disclosed the purpose of our assembly to the independent witness and the trap team. I received the original complaint from the complainant. The complaint also owned the same and its authenticity. A new Philips voice recorder was unsealed and charged electrically at the UCO Bank zonal office. Complainant was asked by me to produce 5 GC notes of rupees 100 each, amounting to rupees 500, and accordingly produced the same. SI Rajesh Kumar gave pre-trap. SI Rajesh Kumar is not examined. Gave pre-trap demonstration of reaction of phenolphthalein powder and sodium carbonate water solution with both his hands. The pink water was preserved and sealed in glass bottle marked as A. I signed thereon. The signature of the witness are identified and marked as exhibit so and so. Thereafter, demonstrating officer kept 5 GC notes in the left pocket of the complainant's trouser. Voice recorder was kept in the left pocket of the complainant in off mode. KC Mondol was asked to remain with the complainant at the complainant and act as a shadow witness. So Miller, he also now comes up and says that the voice recorder was placed in the pocket in the pre-trap process, whereas the other witnesses have either said that it was a mobile phone or it was placed at the voice recorder was placed inside the pocket at the office of the ITO. Divyanshu Khambosh, Miller, I'll skip this paragraph. We'll see from the next paragraph. Except Rajesh Kumar, we all left for the zonal office UCO Bank Shuri at 1:45 on 13/6/13 and reached ITO ward number 3 Shuri at office of the accused at around 2 p.m. situated at first floor. Complainant and shadow witness went upstairs on the first floor and we all were standing downstairs. Voice recorder was switched on. Later, after 7 to 8 minutes, another person entered into the office, later identified as Sushanto Sengupta. At about 2:10 p.m., shadow witness gave a signal to all of us, entered the office of the accused. Complainant pointed out by identifying both the accused person. Voice recorder was switched off. We disclosed our identity. I challenged both of them by taking accepting bribe from the complainant Pulak Mondal. They kept mum. Right hand of Sushanto was washed. Tinted money was recovered from the left side shirt pocket. Thereafter, Millard, he goes on to describe the entire process of the post-trap evidence that took place. It will see from the 4th paragraph then. The facsimile brass seal used during the post-trap proceeding and the signature of the witness thereon are identified and marked as Exhibit 17 and 17/3. Both the accused persons were arrested by me. Accused Bhadre Alam was arrested at 10:05 p.m. on 13/6/13 and accused Sushanto Sengupta was arrested on 10:40 p.m. on the same day. This is important, Millard, but the voice sampling part which I said, voice sample of accused Bhadre Alam was taken in a voice recorder by me. The memory card was sealed in an envelope S1 signed by me. Signature of the witness in envelope S1 are identified and marked as Exhibit MAT 8/6C. So, Millard, they have themselves shown that the voice sample was recorded after the appellant was arrested and without any permission being sought from the magistrate for recording of voice sample of the accused appellant. Millard, the witness also himself says that the voice sample was collected while the accused was already taken into custody by the CBI. Millard. Thereafter, the next line will see the transcript of conversation between complainant and Bhadre Alam was taken by me in a laptop and incorporated in the post-trap memo. Millard, this is the contents of it is again not verified, Millard. The transcript, Millard, has never been placed as exhibit.
Voice sample was recorded when the accused was in custody.
At that point.
First point.
That is their submission. That I will give answer.
Custody and without any order of the court.
Yes. Millard, obtaining permission from the magistrate. Millard, they have themselves stated that after arrest, the voice sample was taken. This is what has been laid down. Now, Millard, Millard, thereafter, page 56, second paragraph, 5th line, Millard, will see it was 56. It was revealed during investigation. Sushanto was an outsider and a private person. Again, a new role of Sushanto. It is not revealed during investigation that Sushanto was a clerk engaged in the tax department. Income tax department, IT department, it is there. Millard, thereafter will report. Millard, then page 57, the last paragraph, Millard will see the officer has also admitted it is a fact that Sushanto didn't demand. It is a fact that Bhadre Alam did not accept the bribe money. It is a fact that Bhadre Alam did not accept the bribe money. It is a fact that bribe money was not recovered from the shirt of Bhadre Alam. Yes. It is also, Miller will see, it is a fact that Sushanto, the last paragraph, Sushanto didn't demand any bribe money. Miller, this is there and 13 is there. 13 is a voter.
Ayo.
Yes, Miller, he is the issue. Miller, I'll just read the last, the cross examination of the I. Miller,
permits in 5 minutes, he can complete the.
Yes, yes, obviously. Obviously.
Well, this is the where the evidences will complete. This is cross-examination, the last paragraph, page 59. On perusing the CD, witnesses stated that the complainant applied online for his income tax refund on 27/6/2012, VDA office machinery docket number so and so. I cannot say whether the acknowledgement number was given or not. The accused was duly bound to process and enter the details in the computer. So I did not investigate with respect online refund process. I did not know refund process is online. I cannot say of CPC Bangalore case directly. Refund through RTGS, NEFT in the bank account directly. I did not see any password of the computer of the ITO, to show that if at all the details were inputted in the input was made inside the computer, because like all the case of the prosecution has, our defense has from the very beginning been that I have no role in processing or payment of the income tax refund. This is done directly online through CPC Bangalore, and our job is only to input or put in the details of
the data.
So there is no evidence to that effect that the data was.
As regards to refund, neither Bhadre Alam nor anybody in within this office had the authority or had the power to.
And in fact, PW1 in his evidence has also admitted that he subsequently, after filing of the case, within a few months got the refund into his bank account. So the factum that the money, the ITR, the return was not at all input made in the computer is also stands substantiated, because the refund was subsequently received by the Pulak Mondal into his bank account. Thereafter, we'll just see the second paragraph. I did not examine office superintendent IT department Shuri. Voice sample and conversation recording of the accused was taken on 13/6/2013.
When in custody.
13/6 is the day where the entire pre-trap post-trap takes place. So after they have said that after taking into custody at 10 p.m. there he says on the same day the voice sample is taken. So it is not possible, because I'll be produced on the next date before the magistrate. 13th, if they have taken the voice sample, it has to be without the permission of the magistrate, because that is the day the entire incident took place. Voice recorder.
He was produced on 14th.
Possibly, yes, it has to be on 14th. I'll check the orders. Voice recorder was at CBI Malkhana. 65B is not applicable in this case, as it is an original, applicable only in 2 copies. These are the depositions of all the witnesses.
Yes.
Kindly fix up a date for us to just complete or wrap up our arguments.
Which
and
day?
Raise these certain judgments, Miller.
Which day?
Miller, I leave it to your lordship. Miller, except Thursday, Miller.
Except Thursday.
Oh, Miller, then.
Circuit bench.
Very well, then after that. After that. And Miller, only one written notes also ready. Very well. Only one indulgence I am praying, Miller. Tomorrow or Thursday, I may be permitted after the court hours in front of your lordship's court officer to look into the lower court's records. In front of the court officer.
উনি একটু দেখবেন, বুঝেছেন, ওই ট্রায়াল কোর্টের রেকর্ডটা দেখতে দেবেন।
Well, both of them may.
Yes, yes, obviously.
Yes,
obviously.
yes.
তাহলে, so after court hours,
Yes, after court hours.
tomorrow after
Didi.
4:30.
Tomorrow after court
Just
hours.
after
Bibli
4:30,
obliged.
ঠিক আছে? শুনলেন তো?
And after returning, your
কালকে
lordship may.
4:30 পর মানে এনাদের তরফ থেকে একজন থাকবেন, ওনাদের তরফ থেকে একজন থাকবেন, দুজনের প্রেজেন্সে ওনারা রেকর্ড দেখবেন, ঠিক আছে? 1 minute, we have not completed this one. The learned counsel representing the substituted, no, representing the appellant, that is the son of the convict, son of the convict, bracketed deceased, further commences his submission and completes the same as regards to deposition of the witnesses. Full stop. The learned senior counsel representing the appellant seeks an accommodation to further submit in this regard and to produce authorities. When
Well, at any day except 17th and 18th. 17th and 18th. I gather your lordship will be
returning on
commencing before the principal bench on the 14th.
14th.
So in that week, 17th and 18th, your lordship kindly excuses me. 15th or 16th. 15th or 16th. Subject to convenience of your lordship.
Can it be on 15th?
Yes.
15th. So 15th at
2 p.m.
2 p.m. So 2 p.m.
Mr.
Well,
Ganguly, only humble prayer is, my lord, does not get annoyed with us. If we are unable to, gives us half an hour leeway to that extent, kindly does not get annoyed with
Yes,
us.
no.
Well, and what
So
happens
let us-
sometimes the matters are fixed at 2.
Let us keep it at 1:30, half an hour.
That would be extremely convenient for me, but otherwise, well, that's why it can, if it is without any time, 2 p.m. 12টা করো না, 12টা হলে তো টুক করে হয়ে যায় আমাদের ওই সময়টা মোটামুটি শেষ হয়ে যায়। 1 ঘন্টা হয়ে যাবে। আমার কি আর লাগবে? Arguments তো। Very well, 12 o'clock I have.
More than half an hour. I
1
think.
hour. Maximum, my lord, I will promise to finish it by half an hour, but a lawyer's half an hour is always 1 hour.
Counsel, as regards to submission, this court is the last person to pressurize upon the learned counsel.
No, that you know, my
You
lord.
are liberal
That
to
we
submit.
know. Lawyer's half an hour is always dangerous, my lord. That's what I. 12 o'clock, my lord. If
12 o'clock on
but fails from
on
learned
15th.
senior advocate.
15th.
15.
Let the matter appear. Let the matter appear on 15th of September at 12 noon.
Great. Your lordship kindly record that I am also present, my lord.
No.
Because, my lord, on one day, my lord, in the other court things are different. My lord, time was taken by the petitioner, and the learned trial court record that CBI counsel is taking time. That is the reason I say.
No, it will be taken care of.
Right.
You're being represented. Have you provided the?
Yes. Great.
I think somebody was absent.
My
CBI was
learned
absent.
friend was no, not here. My lord, that doesn't happen.
Yes.
Great.
Those have been-
Urgency application on item number 50 has been assigned to your lordship. Lord, on the 14th of this month, there was a date in the trial court for evidence. I placed monthly list along with an adjournment application that has been rejected. And date has been fixed on 31st for argument as last chance. So I came to know that your lordship is going to settle September. My matter is running 50, item number 50. Today's list, item number 50. 0336.
What is the matter about?
Well, the matter is nothing. One amendment, the substitution petition has been rejected. My wife is a cancer patient. He initiated a partition suit. When its cancer stage became 4th stage, She transferred her share in favor of her husband.
Hmm.
That petition has been rejected. Nothing.
Petition has been rejected.
Only in respect of her share, not the third party's share or not to a third party.
Hmm.
She transferred in favor of her husband. That has been rejected. And matter has been fixed on 31st, that last chance are
এখানে কালকে কি আছে দেখুন তো, আগামীকাল কি আছে? হ্যাঁ, আছে তো। তারপরে এটাকে দিয়ে দিন, সিও item number 50, CO 336 of 2026, item number 50. CO, you provide the number.
I'm